দুটো আছে বোধ হয়, একটা 12টার সময় আছে। আপনি আপনি অরিজিন সাইড না আপনি আপনার ও অ্যাপ্রেল সাইড জাজমেন্ট একটা আছে। হ্যাঁ, ওটাই আগে হবে, ওটা হয়ে আবার সেই 12টার সময় বোধ হয় আরেকটা 12টার সময় জাজমেন্টটা আমি দিয়ে দিই। জাজমেন্টটা কোথায়? এই বলে দিন অ্যাপেলেট সাইড ম্যাটার ডিক্লেয়ার করুন।
Appellate side matter, item number 1.
আইটেম নাম্বার 2। অ্যাপেলেট সাইড ম্যাটার ফিক্সড।
Number 2.
The revisional application stands dismissed. No costs. Any?
Origin side mentioning.
Purchase may be permitted to mention two matters. Both are PLA matters of husband and wife are praying for inclusion in the list.
Which year?
2023.
It will come chronologically. Okay. Next.
Testamentary suit, my lord. PLN testamentary suit number was there, only for discovery and inspection order.
What is it?
Matter was directed to returnable on 13 March 2024. Discovery and inspection matter was not appeared, my lord. I'm this. To order or
kind leave to mention a matter, my lord. This is a testamentary suit, my lord. The executor has been examined, my lord. It has been fixed for cross-examination. My lord, the difficulty is, my lord, he's gone on dialysis operation, my lord. I was humbly praying, my lord, he's in Kolkata right now, my lord. That is the urgency, my lord. He's on. If this could be fixed, my lord, taken up tomorrow, my lord, or any time, my lord, subject to your lordship's convenience, my lord. He resides in Mumbai. He's come to Kolkata, and my lord, he's under cross-examination. Not a very.
Who is for the other side?
My lord, I've informed the other side, my
Then
lord, not mentioning on notice.
to be mentioned. Okay. To be mentioned.
Lordship's kind leave. Mention item number 61 of your lordship's monthly list, my lord.
Oh, okay.
My lord, this matter part of the application mistake. This matter is already fixed on 5th of April.
দেখো তো দেখে নাও
61. 60.
মান্থলি লিস্ট।
আমাকে টাইম ফিক্স হবে না, 5th এপ্রিল করে দিচ্ছি। তাই তো?
My lord, may I be permitted to mention a probate application of the year 2020? Citations are yet to be issued, my lord.
Yes, mention. What happened?
It may be included in the list, your lordship. I'm deeply obliged.
May it please your lordship, for appearing as to be mentioned. This is in relation to a testamentary matter where the order has been passed for commission and the executor was deposing. But now what has happened, he is not deposing. He wants other witnesses in his place to come in and depose, which is not permissible unless. So I was hoping that it come up as to be mentioned in your lordship. Pass.
Notice, other side,
Yes. I've served notice.
who will mention?
Original set commercial division. Item
Your
number.
Lordship, Your Lordship, I appear for the judgment debtor in this matter. I appear virtually. Kindly tender my apology for that. Your Lordship, I have filed an application which is appearing before Your Lordship's list, GA number 1. That is for a garnishing proceedings. Since the judgment debtor has various debtors from whom I will get money. So I have filed this application for Your Lordship's right to exercise power under Order 21 in the garnishee to pay the money which is due to me directly to the decree holder.
For the judgment debtor.
Yes, Your Lord. I have made out an application for garnishee proceeding so that my debtors can directly pay the money to the decree holder.
My lord,
Yes.
I am appearing for the decree holder, my lord, in this proceedings, my lord. There is a decree in respect of certain outstanding dues and
How
personal
much?
to-
How much?
My lord, the total decretal amount was 12,54,607 rupees. And my lord, this amount, out of which 2.5 lakhs was paid upon continuous delay. They have sought time and again, they have sought for opportunity to make this payment. My lord, no, after 2.5 lakhs, they have been seeking time. Several extensions have been granted. I am only praying, my lord, that the amounts be
This 2.5 lakhs was paid pursuant to an oral settlement reached between the parties before the learned Bankshal Court, which relates to a check bounce case, which is the main basis for filing this suit in which decree has been passed. So, Lordship, 2.5 lakhs we have already paid. We have filed an application that we have certain money due from various debtors.
today they have come up with an application. This is another dilatory tactics by them, my lord. My lord, they have once they
No, not a dilatory tactics. Your Lordship, if I am entitled to under law, I can.
certain
Order
payment
21
after
46
entering into
provides
the
it.
settlement, how can they come up and say that I will procure it from garnishes and then make payment?
No, you don't
Procure
have to procure. The court will pass
As
orders.
they not have that amount in their account, they should not have entered into that settlement. They enter into a settlement, they ought to have honored it. My lord, this 12.5 lakhs was subsequently a final figure of 10 lakhs was arrived at. But that also they have breached.
If Your Lordship, I don't have the funds now to
Some
pay.
of
If
that.
I can show that there are various debtors which are disclosed in my affidavit of assets, that this is the
Clearly
money due.
stating that would not have. If
I
they
am entitled under law. Your Lordship will kindly exercise that power under Order for 21 Rule 46.
You are appearing
Your
for.
Lordship,
I'm led by Mr. Banerjee.
Oh, I see. So you have to. We have to take up this application.
my lord,
yes, Your Lordship, we have.
the application, but my lord will only see the respondent, the judgment debtor's conduct.
Your Lordship, I understand we have entered into a settlement. We have paid 2.5 lakhs. But as of now,
Just a minute. There are some problems. The department does not send the requisite papers. Not today.
Okay. Lordship, may I only pray for one thing? Can it be taken up on 7th
no,
instead of
So
6th?
I have given you enough time. Every time I
No,
cannot.
this is appearing for the first time for Your Lordship.
Yeah, why
This
you?
matter that's a different matter.
Why you are in
That's a different matter with where I appear.
My lord,
I am grateful.
Kind indulgence, the garnishee application is appearing as GA1. Probably it will be GA commercial 1, subject to correction.
এই ওটা কারেকশন করে দেবো
much obliged, my lord.
Grateful.
next
Item number 2.
My lord, Mr. Chaudhary had started his submission yesterday in reply to the submissions made by the defendant numbers 1 and 2, lordship.
but you have failed to show some Master summons or prayers.
Yes, my lord, we took instructions, my lord. It has been filed, my lord, because my advocate on record says that, my lord, it has been found.
Okay.
My lord, we were on the GA2. If lordship takes up the master summons, the prayers are set out. GA1, my lord.
All parties are here.
My lord, different number 2 is here.
Here, pass over, pass over. Next.
Item number 3.
Yes.
Lordship, I appear on behalf of the decree holder, Lordship. Lordship, the yesterday was this matter. Lordship, that
সমস্ত documents এসছে documents
that matter was yesterday. The matter was appearing in the original side list, Lordship. The commercial matter. So, Lordship, that the last occasion, Lordship, that I was praying for Lordship direction to take physical position by the receiver, Lordship. Receiver is already appointed and taken the symbolic position. So there's because there is no specific prayer to that effect in the table of statement, Lordship. She may kindly, Lordship, may I humbly suggest one thing, Lordship, that Lordship may kindly make it out of list with the liberty to mention the matter, because the Lordship, the client is outstation client, Lordship.
the learned counsel for the
Lordship may kindly give the liberty to mention, Lordship, that so that I can.
learned counsel for the decree holder has prayed for accommodation as his client is not available right now. Stop. The matter goes out of list. Liberty to mention. Matter goes out of list. Liberty to mention.
Grateful, Lordship.
Appearance. কি pass over পরে হ্যাঁ
Non-commercial. Original side matter to be mentioned, item number 1. Item number 2.
This is appearing at my instance. I'm a propounder in a testamentary suit. Millard, this suit was arguments on behalf of the propounder was on the verge of conclusion before the previous bench, Millard. We have completed our arguments. Only 3 or 3 judgments will be cited. So, Millard,
who heard the argument?
I beg it.
Who heard the argument?
My Lord, Mr. Justice Rao.
Who will pass the judgment?
I beg your Lordship's pardon.
Who will pass the order?
No, Millard. So, in the order, it is recorded that the hearing has taken place at length. So, Millard, I had mentioned the matter before Justice Rao, Millard, to say that if it can be marked as part heard,
Yes.
so that
Oh, I have to release this, no?
yes, Millard, so that it can be assigned and it can be concluded.
The learned counsel for the
Millard, this order records that it has been heard at length.
has submitted that
Let's record it then. It's not by submission; it's a court record.
that the matter has been argued before another honorable coordinate bench at length. Stop. In this regard, the learned counsel has placed before me the order dated 7th February 2024, passed by the honorable coordinate bench.
Lordship, I am appearing for definitely number 2 and 4. Kindly record that.
My learned friend is not opposing
I
this.
am not opposing this.
The learned counsel for the respondent number
2 and 4.
2 and 4 have also admitted the above factum. Stop. As the matter has been substantially heard by a coordinate bench, the matter should be released from this bench. So, accordingly, the matter is released from this bench. Anything else?
I'm sorry, Millard, I had to make this prayer. Generally, we don't do it. But Millard, the clients are at the verge of exhaustion.
Certainly. Next.
Item number 3.
Lord.
Yesterday, my lord, it was
এই রেকর্ডটা দাও তো।
inquired by your lordship whether the general citation has been made. My lord, may I produce a copy of the affidavit of second officer of the deputy sheriff, where he has filed an affidavit stating that the general citation has been made.
Already made.
Already made.
So you have told me yesterday that general citation is not required.
No. He told that since the records were not currently with us, we'll have to, the matter was adjourned for the day. Thereafter, we traced out the record and found out that the affidavit of the.
So general citation was done.
Yes.
Okay, এই দেখি ওই রেকর্ড এটা দেও তো। আগের দিন অর্ডারটা দাও তো। এটা কে নিয়েছিল? এটাকে আরো বলে দেবো একবার। Learned counsel for the petitioner, namely Manuel Rosario. Manuel Rosario has submitted that special citation as well as general citation.
Also, the copy of it is with us.
Was done. কি বললাম আরেকবার? General citation were done in respect of Samuel Rosario and Antonia Sao, SHAW, Antonia Sao. Is it correct?
Yes, sir.
In respect of both the persons, general and
My lord.
Stop.
Special citation and
Stop. Nothing was heard from Samuel Rosario in spite of citation. Stop. Antonio Saw has filed caveat, but as she did not file any affidavit in support of caveat, comma, the same has been discharged. Stop. The other son of the deceased, namely Xavier Rosario, has submitted affidavit of consent. Stop. As such, there is no impediment to allow the prayer D of the relevant petition. Stop. Para. I have considered the affidavit of consent and other materials on records, including the report of the registrar in insolvency, High Court, original site, dated 23/11/2023. Stop. In view of the above, comma, let there be an order in terms of prayer D. So matter is disposed of. In fine, the matter is stands disposed of. Okay, আর জেভিয়ার বানানটা কি লিখবেন? হ্যাঁ, এইখানে একটা ভুল, এটা আগের দিনের অর্ডার, যাই হোক এটা দেখার আপনার দরকার নেই। এক্স এ হবে এটা, ঠিক আছে? তাও এটা রেখে দেবেন, আমি এটা দেখবো পরে। কেন থাকে, কিন্তু ওটাকে কিছু চেঞ্জ করেছি, বলে দিই।
Execution cases, item number 4.
Lord, I was making my submission. I will try to be as short as possible and conclude. Lordship has more or less heard me on the point of valuation and subject matter jurisdiction. May I just indicate the points?
না 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 আমার একটা interest আছে। বলে দেখি বুধবার বুধবার এখানে কি
স্যার 11টা ম্যাটারে আমার অর্ডার দেয়।
आपको नंबर करो आगे दिन ছিল
Milord, may I, Milord, start? Milord, this is a case, Milord, just Milord 3 points, where the lease has expired by efflux of time. Initially, Milord, there was a lease which of Milord 21st of January 1997, that was the lease deed. It was 20 for the period of 21 years, commencing from 31st, Milord, with effect from 31st December 1994. So it has lived this life, and by expiry of time, Milord, it has come to an end. Milord, after the lease has come to an end, Milord, suit was filed with an application under Chapter 13A of the original side rules. This is like, Milord, the Order 37 suit, Milord. In that suit, Milord, Milord, an application was filed. It was only my application, that is the application under Chapter 13A. Milord, there is a decree. There was no application under Section 11 of the Court Fees Act, or Milord, there was no application for return of plaint. Now, Milord, to return of the plaint, one has to have an application that is well settled. If, Milord, the court is dissatisfied with the valuation, Milord, there should be an application under Section 11. Milord. That was also not. The matter was heard, Milord. This Thika was point, Milord, the protection under the way that it was not, Milord, never the case of Milord, my learned friend, that he's a protected tenant under the West Bengal Premises Act. His case that it was a Thika property and the suit suffers from overvalue. These are the 2 points. In both these courts, Milord, the Honorable Single Judge, Milord, has held in my favor and has passed a decree for recovery of khas possession of the premises in question. Against that, Milord, they have preferred an appeal. There's a conditional stay, there's a breach of condition, so I'm entitled to execute the decree. Milord, now, Milord, when the matter, Milord, there is already an order that the receiver will take symbolic possession. Now, when, Milord, I press, Milord, because there is a breach, there is no embargo on me to proceed with the decree, as held with the Akmaram's case, Anderson Wright, and, Milord, the other cases, Milord, which are on board, Milord, including of 2 of the division bench orders, which I'll only show, that I am free to proceed with the decree. My learned friend today, Milord, doesn't have an application under Section 47 of the Code of Civil Procedure. Because Lordship knows, Milord, if it is there is a decree between the same parties or their legal representatives or anyone, Milord, who is, Milord, claiming through them or otherwise in possession, fresh suit will not lie after 1977 amendment, Milord. There has to be an application in the nature of Section 47. So Lordship is not hearing, and that Lordship today, Milord, to hold my decree is inexecutable. Milord, there is no application under Section 47. This is my first point. So, Milord, if there is no application under Section 47, it cannot be, Milord, a stage the decree Lordship can hold, Milord. The decree is inexecutable. Lordship has to proceed with the decree. Now, Milord, so overvaluation and, Milord, as an executing court, Milord, Lordship's court cannot go behind the decree or cannot interpret a law to say, Milord, the decree, Milord, suffers from overvaluation. Like, Milord, my learned friend has tried to argue that 1976 Supreme Court 3-bench judge is not a good law because, Milord, the provision of West Bengal Premises Act 1997 Section 20 and the schedule appended thereto, schedule number 4, is materially different from schedule appended to West Bengal Premises Act 12 capital A, Milord, where the fourth schedule is there, where Millard market value of the property is not there. Now, my response is, Millard, my response is, Millard, very categorical. The response is, look, you are not you have not claimed to be a protected tenant, Millard, under the Rent Act. So whatever is the question of market value never really pinches you. What, Millard, is the guiding factor which is still there in 1997, Millard, that is, Millard, of the Act of 1997, scheduled to Section 12, capital A, that, Millard, says, Millard, valuation of the suit is rupees 10 lakhs. High Court will have jurisdiction. Now, Millard, valuation is always on the plaintiff, and even the 1976 Act proceeds on such basis. I'll show the judgment. It proceeds on such basis. My learned friend has cited a judgment of Nelimara Jute Mill, Millard. It is not a case, Millard, of Millard Section 47. It is a case of Order 7, Rule 10 of the Code of Civil Procedure, read with Section 11 of the Court Fees Act. Here we are not deciding that application, Millard, application of such type, because there are decrees already on board. Those are the objection, Millard, pre-suit, because it's a objection regarding pecuniary jurisdiction, not an objection regarding, Millard, the subject matter jurisdiction. Now, Millard, kindly have a decree once, then I show 2 paragraphs of the judgments, 3 judgments, and I end my submission and distinguish Nelimara Jute Mills. Kindly have a look at the decree at page 17 of the execution application. Kindly have a look at it. Millard, my colleague Mr. Dasgupta, Millard, is saying that you are distinguishing the judgments 3rd time. Once before the learned single judge, once here. Millard, appeal court, he was there, I was not there. Millard, kindly have a look at running page 21. Kindly have a look at it. Mr. Such and such, page 21, running page. I'll be very cryptic, Millard, very cryptic. Mr. Such and such, learned advocate representing the defendant, submits that this court does not have jurisdiction to entertain, try, determine, or adjudicate the present suit. He further submits, page number 17, he further submits that this court does not have pecuniary jurisdiction to entertain the suit filed by the plaintiff. Thus, an application of the plaintiff is required to be dismissed. So, pecuniary jurisdiction, not subject matter. That is argument. Mr. Such and such submits the defendant is a Thika tenant, and the suit property, any dispute whether the defendant is a Thika tenant or not, is a subject matter of Thika controller under the West Bengal Thika Tenancy Act 2001 and amended. He submits the subject property of the present suit is within Posta Bazar, whereas most of the business structure have already been approved by Thika controller. Now, Millard, he has filed a challan. Mere filing of a challan ipso facto does not render the property into a Thika property. So, this is a objection regarding subject matter. But the decision bank says, Millard, this is not a Thika property. I'll just show this judgment. It is referred there. Mr. Such and such submits the para 22, the fact of construction of structure on the subject land on the southern premises number Mohashri Devendra Road was within the knowledge of the erstwhile landlord at all material times. The defendant has complied with all legal requirements as followed in section 25 and 38 of the Calcutta Thika Tenancy Acquisition Act 1981 respectively, and the defendant comes within the purview of the Thika Act. Mr. Such and such submits the plaintiff has valued the suit on basis of the existing market value of the premises, but the plaintiff has filed a suit for eviction on the ground of efflux of time that the suit ought to have been valued under the provision of section 712 of the West Bengal Court Fees Act. He submits that the monthly rent of the premises 2,000 inclusive of maintenance charge at the time of filing suit. Thus, the valuation ought to have been 24,000, but the plaintiff has overvalued the suit. So, this is his sheet anchor of his argument. Now, Mr. is barred under the provision of section 21 of the Thika Tenancy Act. Now, Lordship will kindly, Millard, Lordship will find that, Millard, kindly take, Millard, para page 23. It's, Millard, in paragraph 21 of the plaintiff has specified the value of the suit property as rupees 3.57, bring the market value of the suit. The plaintiff has shown the value as per the valuation report of the Talbot Company in the case of such and such. This is the Supreme Court 3 bench, Millard. This is the learned judge courts Then Millard, page 24. I'm not reading Millard the entirety. Lordship has seen it. Nelimara jute mill supra has been quoted. Now Millard, kindly take Millard para 25. Page 25. I'm sorry, Millard. The Honorable Division Bench of this court, while deciding the case of Nelimara jute mill supra, the judgment passed by the Honorable Court in such as Moulavi Rav such and such was not brought to the notice of the Division Bench. In view of settled position, this court finds the plaintiff has already valued the suit property. Now, Millard, a court where Millard the suit was heard, he Millard takes a finding that I will follow Millard the decision of a larger bench of the Supreme Court, not the division. Millard, as an executing court, Millard, to Millard interpret this provision.
The only ground.
Yes, to interpret the provision. There are other grounds I'm showing. Millard, today, Millard, Lordship has to do Millard a re-adjudication, Millard, which act has to apply, which judgment has to apply. So Lordship will be in effectively going behind jurisdiction. Lordship can't do that. Lordship can do, but it's not legally permissible. I'll put it in this way. Lordship can do, but it is not legally permissible.
Then
of course.
You're asking me to do illegal things.
Millard, I cannot say.
I was under the impression that as this point has been taken in the appeal court and appeal is pending.
No. This is what this is
wait.
my.
We
No, this is not my friend will.
We should
No,
wait
he is very fair, Millard, that way. He will never make this. This is Millard, my misunderstanding.
We should wait for decision.
This is squarely taken. Millard, in fact, Millard, this was a query.
Submission.
Trial court.
This point was taken in the trial court. This point has been taken in the appeal court also, and that is pending.
Absolutely.
There's no.
I was on that point only.
Yes, this was taken. This was taken in the trial court. This was taken in the trial court. It could have been a situation, Millard.
Yes.
What fell from your lordship? This was not taken in the trial court. Today he comes and takes up this point. Then, of course, Millard. But if your point is already taken, I mean, don't. I'll not say that. If it was a point, Millard, today, Millard, certainly, Millard, springs up, Millard, that this particular today, Millard, under the West Bengal Premises Tenancy Act or, Millard, any tenancy of the government, Millard, civil court will not jurisdiction. It will be decided by a specialized body. It's a subject matter jurisdiction. It is not taken before the decree court or the court which has passed a decree. Now, if that point is taken, Millard, obviously, Millard, lordship will go. But if a point squarely taken,
these are not stated here that this is subject matter jurisdiction.
No. He has said pecuniary.
Only that was not brought to the notice of the Honorable Division Bench.
Yes.
In view of the settled position of law.
Yes. Now, Millard, he doesn't, Millard, say, doesn't Millard formulate his decree only on this. Kindly have a look at page 26. So he follows the Supreme Court. Whether he was right in following the Supreme Court or he should have followed the division bench by distinguishing the Supreme Court, look, it is a question of going behind the decree. That is perhaps not permissible. Now, Millard, kindly take page 26. The defendant has filed an application before the Thika controller to the notice of a spot verification issued by Thika controller are subsequent to the filing of the present court sued by the plaintiff. In the case of Amala Palit Supra, the Honorable Division Bench held that the mere deposit of rent with the Thika controller cannot ipso facto create a Thika tenancy. So, Millard, lordship has a look at the Amala Palit's judgment. Kindly have a look at that para. Not that he has brushed away all division bench. When a Supreme Court is cited, he follows the Supreme Court. Kindly have a look at Millard Amala Palit. Copy them. Kindly have a look at, lordship gives me a moment. Just a minute. Kindly, Millard, have 2000. This is Millard. This was also cited. This is 2015 4 CHN Calcutta 213.
2015.
2015, it's on the top. 4 CHN Calcutta 213. It's a division bench. Now, lordship I'll only show Millard one paragraph. I had shown 16 and 17. Kindly have a look at Millard. Paragraph 16. Admittedly, the subject tenancy was not covered by the 1949 Act, para 16, lordship. following the decision in the case of such and such and Lakshmimani Dashi, 1981 Act could only be applicable in the tenancy prevalent under the 1949 Act. Slum and khatal were added. The subject property is neither a khatal or a slum. This is the division bench is saying, not a slum. Mere deposit of rent with the Thika controller would not ipso facto create any Thika tenancy. Lease was executed in 1964. It was for 21 years. Since it was a lease beyond 12 years, 1948 9 Act did not have any application. 1981 Act included slum, khatal, bosti. It's none of them, Miller. It's a multi-storied building. That would have no application in the instant case. In the said decision, in the case of Darkanath Akoli, the Thika controller himself admitted he did not have jurisdiction. Now, paragraph 18. Last three lines. Admittedly, after a long time, appellant did not pay any rent. The appellant has claimed, the appellants have claimed they deposited rent with the Thika controller. Such deposit would have no consequence. So division bench says it is a Thika property. So subject matter jurisdiction is gone. So what falls to before your lordship is, Millard, a pecuniary jurisdiction, which can be waived. Court can even ignore it. Millard, I have shown the judgment. Appeal court can also ignore it. Now, Millard, kindly have a look at just Millard. Amula Palit is quoted. Now, Millard, kindly Millard, take Millard, page number 29. This is what Millard, in effect, the learned single judge has followed. It's a division bench. Millard, I have not got the SLP. The SLP was dismissed. Of Millard, page 29, Prakashvati Chopra and Shivaji Mitra, both point taken. Even Millard has more point taken, Millard, that the property which is not taken here, a subject matter jurisdiction. Millard, the tenant is a person who is protected under Millard as a tenant under section 2G of the West Bengal Premise Tenancy Act 1997. Kindly have a look at page 29.
Page 29
of Millard, the execution application. Lordship finds, Millard, middle portion. In the present case, kindly look at why it is not Thika. Why this is, Millard, a moonshine defense. There is a finding of the court. In the present case, the building situated at the premises is a multi-storied building and in thus cannot be said to be a Thika tenancy. So if there's a multi-storied building, it's neither a slum, nor a khatal, nor a basti. So how it can be a Thika tenancy? In Bengali, Millard, Thika are what property? They cannot build a permanent structure. The first floor is made of wooden. The top is, Millard, hatched, Millard, a temporary structure. It's a multi-storied building standing. In the case reported in 2006, SCC Online, Prakashvati Chopra versus Shivaji Mitra, the Honorable Division Bench has detailed the question. Now kindly take, Millard, the judgment itself. One paragraph. Kindly have a look at it. This was also cited. It's a division bench. And Millard, I am not finding, Millard, the SLP which was dismissed from this order. Exact same to same, Millard. And Millard, this has been followed in no uncertain term. Kindly have a look at paragraph 1. After this, I'll distinguish the Nelimara Jute Bill and conclude. Yes, the first paragraph, same, exact same like us. By a registered lease deed dated 5th January 1973, the premises number such and such, Gangadhar Babulen Boubazar 12, was demised to defendant by the plaintiff for a term of 21 years commencing from 1st January 1973 and ending on 31st December 1994 at a monthly rental of 850 rupees payable in advance of the 7th day of every month. So, Lordship, Millard, if Millard, that argument is taken, 850 into 12 will take the rent, Millard, of 10,000 rupees. Is below, Millard, 10 lakhs. So, this court will not have jurisdiction. So, Millard, I showed this paragraph. Now, Millard, kindly take paragraph 2. The lessee deposited a rent of rupees 10,200 as by way of advance, which the lessor agreed to grant prepaid of 70,000 per month for a further agreed amount. Now, kindly take the clause. at the expiration of the term of the lease or sooner determination thereof, the lessee shall quit and vacate and give peaceful possession of the demised premises to the lessor. Now, my lord, kindly now have paragraph 3. The lease came to an end on 31st December 1994. Suit for recovery of possession together mean profits at the rate of 5,000 after expiry of the lease was filed on 9th October 2002 on the sole ground that the lease has expired by efflux of time. This, my lord, the suit was filed. Now, my lord, kindly take, my lord, that paragraph, if I read it, kindly take, my lord, the line starting with however. And in fact, my lord, lordship, I'll read on. The plaintiff had claimed a decree for vacant and peaceful possession for a sum of rupees 1 crore 21 by way of mean profits and future mean profits together with interest at the rate of 12% per annum. In the aforesaid student application for summary judgment, the chapter 13 was filed and allowed. Exactly like us, my lord. Was allowed by the learned trial court by a judgment and order dated 17 February 2006 in as so the prayer of recovery of possession was concerned. So, my lord, mean profit adjudication is pending. So, part decree, like the present case. However, the prayer for a decree on account of the mean profits have been relegated to the trial. However, the contention of the defendant that the provisions of West Bengal Premises Tenancy Act 1997 hereinafter applied to the lessee and was negative by the learned trial judge on the basis of section 3 of the act by a registered deed executed before the act came into force, which specifically executed. The trial court further held defendant after expiry of the lease was in wrongful occupation of the premises and was a trespasser having no protection whatsoever in law. This is what the appeal court is holding. After the lease has expired, there is no protection available in law, you are a trespasser. This is the division bench affirming the trial court's judge ratio. Now, kindly have a look, my lord. Paragraph 18. 18. 1-8. I just show, my lord. It's a chapter 13A case. I only showed that, my lord. Mr. Mitro submitted, was appealing for the, my lord, the plaintiff, my lord. Mr. Mitro submitted that the status of a lease whose term has expired is that of a trespasser. Chapter 13, capital A, Rule 1 specifically allows the plaintiff to apply for a summary judgment in a suit seeking recovery of possession from the person whose term of a lease has expired and therefore nothing in wrong in applying the aforesaid provision. So, our rules provides. Now, kindly take, my lord, para 22. Because I am showing this because he has showed, my lord, there is, first of all, my lord, it's not a case, my lord, that he is a protected tenant under the West Bengal Premises Tenancy Act. He is not a protected. That is not his case at all. Here, this case was there. So, my lord, that taking away the market value from, my lord, the schedule of 12A, which I will show, is of no consequences. Because, my lord, point number A in the schedule remains. The valuation of suit should be rupees over rupees 10,000. 10 lakhs, sorry. It was 10,000 before. Para 22. Two issues. Whether the application for summary judgment was entertainable, whether leave should be granted to the defendant, granted defend in the facts of the present case. These are the two issues. Now, kindly take, my lord, I omit, my lord. Kindly have a look at paragraph 29. 29. We therefore are of the opinion, this is the ratio. Lordship has seen, my lord, trespasser, my lord, whose period of rent has expired. That is, my lord, the single judge's view. It is now being merged with the division bench. We therefore are of the opinion that in those cases where the lease has expired by efflux of time, but the lessee is continuing in possession, she would not come within the purview of the tenant under section 2G of the Act of 1997. The judgment in case of Siaram Chandra does not really lend any assistance in resolving the controversy involved in the present case because of the Act of 1997 has to be construed in own background and not in the celestological manner as suggested by Mr. Thorat. The first point is thus answered in negative. Once the first question formulated in answer of the principal question of Mr. Thorat is taken care of. So, my lord, the first question that he is not a thika tenant, it was the second question answered in negative. Second question of valuation becomes, my lord, according to division bench, my lord, academic one. Now, my lord, kindly take. The first point is thus answered in negative. Once the first question formulated above is answered in the principal contention of Mr. Thorat is taken care of, there is no question of any bar being applicable to the entertainability of the present suit, and this court was naturally competent to receive, try, and determine the suit. So it's a natural forum because our rules provides for. Now, my lord, kindly have a look at this. Para 30. The submission of Mr. Thorat that learned judge was wrong in proceeding on the basis that the defendant is a trespasser after expiry of lease, in our view, is not in our view significant. That was the argument. Trespasser not from the very beginning, but trespasser after Millard, when the lease has expired. That Millard has been also argued here. The submission, I read again, Millard, submission of Mr. Thorat, the learned was wrong in proceeding on the basis defendant is a trespasser after expiry of lease is not in our view significant because the question of legal status of the defendant appellant after the expiry of lease. Now, Millard, kindly take the next one. What was sufficient is whether the case comes within the purview of chapter 13A of the original side rules. We have already quoted rule 1, chapter 13A of the original side rules. It would appear that the suit for recovery of immovable property with or without the claim of rent profits by a landlord against the tenant who has terms that expired is specifically provided. The second question formulated is thus answered in affirmative. So our rules, we can go forward and file these suits here on the basis of mean profit or Millard on the basis of whatever way I gave Millard the indication of my value of the property. Now mean profits will be calculated as relegated to trial. Now kindly take Millard the last para 33. Why protection should not be given? This is also kindly take paragraph 33, third line. There is no gainsaying that the plaintiff could not have filed the suit earlier, but the plaintiff did not do so. That alone will not go to show the plaintiff has assented to continuance of the defendant to the agency. There is nothing Millard in the present case. It's not even pleaded. Court cannot be oblivious of the fact that a huge property in the heart of the city is let out at a sum of rupees 850 per month cannot be allowed to be continued by anyone if he can't help it. It is therefore all more difficult to infer the plaintiff assented to continuous defense. The requirement of 160 is actual acceptance of the rent. Unilateral will not do. So, Millard, the division bench says that you cannot enjoy someone else's property at a meager rent of rupees 850. You have to go. These are all technical defense you are taking today. So, this was also argued. Now, Lordship comes back to page 21, where Millard, learned single judge, has formulated the three issues. Page 30 bottom. I'll just indicate and give your Lordship the answer. And distinguish Nerimara and take my seat. Page 30 bottom. In the present case, page 30 bottom, these are the issues which are answered against the defendant here, and a decree has been passed. In the present defense, three defense. One, suit is overvalued and this court is not having jurisdiction. A. B. Number 2, the property is a Thika property. Millard, that Lordship has I have shown the division bench judgment. It's not mere filing up. 3, defendant has already initiated proceedings before the control. These are squarely taken. Now, Millard, kindly take Millard the next paragraph, 31, page number 31. The defendant asserted in its written statement that the suit value was undervalued. It ought to have been valued by a rent of 1 year's rent. Perhaps the use of the word undervalued is a mistake and overvalued. The statement is in the plaint being squarely in accordance with law and not contrary to it. It's a finding of Millard law and fact. This is a finding Millard rendered in my favor. The High Court was the preferred forum for institution of and trial of the suit. The plaint could not be instituted in city civil court that the defense of the defendant is not sustainable. Now kindly take the next one. As regards Thika tenancy, the defendant has filed an application under section 5(3), section 9, 10 and 11 of the West Bengal Thika Acquisition Act. The defendant has filed an application before the rent controller on 11th October 2000 after the expiry of lease after institution of the present suit. Next, The defendant has not filed any document which would show the premises is a Thika property. The assessment book of the Kolkata Corporation reveals that the suit property was described as house and shop. So when I gave that, I was not obliged, and I gave that. The plaintiff and predecessors have paid adequate terms in terms of West Bengal Multi-Storied Building Act. So property is assessed as a multi-storied building. How can he get it Thika now? In case of Amola Palit and others, Honorable Court has held that mere deposit of rent with the Thika controller cannot ipso facto create a Thika tenancy. That is, he is following Millard, Amola Palit and the other Millard, the Shivaji Mitra's case Millard. Now Millard, next. The plaintiff, before expiry of the lease, has issued a notice dated such and such, calling upon the defendant to vacate and hand over the provisions upon completion of 21 years. In this way, plaintiff has also informed defendant in default of such recovery of possession we instituted. In spite of receipt of the notice of termination, defendant has not vacated the property. It is found from the record the defendant all along has received reserve summons but has not filed a written statement in view of court defense set by the illusory, and order has been passed a decree. So where is Millard? The question of re-adjudicating the issues here again. When Millard appeal court has imposed a condition. Now Lordship will kindly have a look at his Nilimara jute mill. What was the application filed there? Today we are not hearing an application under Order 7, Rule 10. Nilimara jute mill take to Deventu. Kindly just one paragraph I will show. Nothing more than that.
You are distinguishing.
Yes. That is, yes, cited. That is the thing I need to distinguish. Kindly have Nilimara jute mills. আছে তোমার? It's a division bench. Kindly take Millard first paragraph. This was cited, and the learned single judge, in its wisdom, Millard, distinguished these said judgments. It cannot be distinguished before the same forum again. The market value exceeds rupees, the market first paragraph. 11, the premises exceeds rupees 10,000. Since the plaintiff is claiming possession from a trespasser who has right whatsoever in occupation and enjoyment of the property, has valued the market value of the property in excess of 10 in the premises, this court has the city civil court does not have any jurisdiction. Now, Lordship will look at Millard on the lighter note. The author here, Justice S.B. Sinha, is the author same of the judgment which I have shown in section 47 on a decree, on a section 47. The author is the same. So, in that stage, it may be a good point, very lucrative point. It may not be a lucrative point when a decree has been passed. There are stages of a suit. Suit in the stage, Millard, before trial, Order 14, Rule 2 stage, thereafter the decree stage, then the decree, Millard, thereafter the executing stage. Now, Lordship will kindly have a look at what was Millard filed. Section paragraph 11, paragraph 17. 17. If the plaintiff does so, overvaluation.
It does not tally with my.
Lordship, so Manu Patra copy or the SCC copy, Lordship?
SCC online.
Baba. Ache. May I just find out from my lord? কেন আমারটা কেন এরকম দিয়েছো? ওখানে ও দিয়েছিল, তুমি ঋষাদ ওখানে আমার ওটা দিয়েছিল, ওটাই আছে। এটা কোথায়? 16, paragraph 16, Milan. I'm sorry, just one paragraph up down. Well, at paragraph 3, Lordship will find there was an application under section 11 of the Court Fees Act. That is reiterated in paragraph 16 of the judgment in question. Lordship's paragraph will be paragraph 16. If the plaintiff does so, the application of demurrer is maintainable in terms of section 11 of the Court Fees Act. So you can file an application under section 11 of the Court Fees Act with a order 7 rule 10 for rejection of the formula return of the plaint for being presented in an appropriate forum. So it's not a section 47 case. I am Miller on a better footing now because no application under section 10 was ever filed read with section 11 of the Court Fees Act. So how this judgment Miller applies in the present case? Because post decree the consequence will be different. You have not taken that. As a defense to chapter 13, you have taken that. The learned court has negated it. This was a case, my lord, of an application under section 10 of the Code of Civil Procedure, section order 7, rule 10 of the Code of Civil Procedure, read with section 11 of the Court Fees Act. And in fact, my lord, para 29, the plaint was returned to be presented. It is para 28 of your lordship, to be presented before an appropriate forum. So this, my lord, doesn't apply. And why it doesn't apply, my lord? Now, lordship, my lord, takes, my lord, one, my lord, that's 76, where so much of 76 to them, which is quoted in the judgment. There are two parts. First part is special procedure of High Court. The second part, my lord, is the schedule of the West Bengal Premises Tenancy Act 1997, and my lord, the schedule of my lord, of the 1956 Act, section 20. I am carrying those, my lord. My lord, this I think Mr. Medora has already given a copy. This is, my lord, 1976 1 SCC 295. Lordship must have a copy, SCC printout. I am not, my lord, unnecessarily giving copies because Lordship's marking should be in one place, my lord. Otherwise, it becomes very difficult. Like we get, my lord, 3 briefs, my lord, 3 at a time, it becomes very difficult for us to do. Kindly have a look at, this is a 3 bench of the Supreme Court judgment. The full bench. Kindly have a look at the full bench judgment, my lord. Kindly have a look at it. Kindly have para 2. Mr. Purushottam Chatterjee, previously, my lord, one has to see it's a lease or a license or a tenancy on the basis of the agreement in questions. Lordship knows, my lord, this field much more than I do. Now, after 1997 Act, promulgation of 1997 Act, one has to see, my lord, the quantum of rate and, my lord, the nature of document. If the nature of document is a lease in question, a registered lease, where, my lord, this, my lord, how we have to value the property will have any effect, my lord. Kindly, my lord, takes, my lord. This is exactly Supreme Court says, paragraph 2. Here, my lord, Calcutta High Court, my lord, trial court passed a decree. Division bench set aside the decree. And matter went up to the Supreme Court. My lord, para 2. Mr. Purushottam Chatterjee, the learned counsel for the appellant, urged the following points. A. High Court had no jurisdiction to try the suit. Only City Civil Court at Calcutta has the jurisdiction to try. Same argument here. There could be no reasonable requirement. We are not on that. Now, my lord, 3 is also not there. 1, my lord, only 1, because he is on fairness. He has said that he is not claiming protection. Now, kindly take, my lord, para 3. Second portion. The relevant portion of the schedule runs as under. Where the value of the suit, it's West Bengal, or, not and, my lord, it's or. Where the value of the suit or the value of the premises for recovery of possession is claimed does not extend rupees 10,000 to City Civil Court as defined by the Act. B. Where the value of the suit exceeds rupees 10,000 to the High Court at Calcutta. So, my lord, A, my lord, is, my lord, for the purpose who are claiming protection as a tenant under the 1997 Act. So two figures. One is, my lord, value of the suit and the value of the premises. Otherwise, if, my lord, someone is not claiming a protection under the Act, then, my lord, where the value of the suit exceeds rupees 10,000, Justice Gupta's judgment. Now, my lord, kindly take section 20. Next part, section 20 is couched in a language which does not determine merely the place of suing but affects the jurisdiction of one court or the other. If the schedule of the suit is triable by the High Court, city civil court has no jurisdiction, while on the other hand, if the latter has jurisdiction to try it, the formal will have no jurisdiction. The inclusion of the word proceedings in section 20 of the Amendment Act will not make any difference. For the purpose of this point in issue, the schedule, however, did not seem to be happily worded. It is not difficult to spell out the intention of the legislature. Next paragraph. Under Section 8 of the Suit Valuation Act 1887, except the exceptions mentioned therein, the value of the suit for the purpose of court fees and jurisdiction. Under Section 7, 9, C of the court fees, amount of court fees payable in a suit for recovery of immovable property from a tenant is on the amount of rent for the payable for the year next before the date of the claim. If a suit was to be instituted in the court which two acts should apply, the value of the suit for the purpose of jurisdiction, court fee will be the amount of the rent paid during the 12 months. But on the next is most important, Miller. This is what Miller, the way on the but on the original side of Calcutta, the procedure followed and the law applicable is different. That's Justice Gupta's judgment. Because if a court has arrived with a natural forum, I am entitled to give him a decree. That is, Miller, Justice Gupta's division bench is saying. Now, Miller, this is, Miller, exactly the same. In the instant case, the rental was about 110 per month. On the basis of the value of the suit ought to have been 1300 only. That being the suit according to the contention of the appellant was entertainable only on the city civil court and not on the High Court. The argument so presented does not, however, stand scrutiny. Within the local limits of original jurisdiction of the High Court, Calcutta legislature thought to provide the value of the suit exceeds rupees 10,000. Now it's below 10 lakhs. It was only entertainable by the High Court at Calcutta. If the value was below 10,000, city civil court only will have jurisdiction. But apart from the value of the suit, if the value of the suit premises on which recovery of possession is claimed exceeds rupees 10,000, then the city civil court will have no jurisdiction to try such suit. Only High Court can entertain a suit. The intention of the legislature seems to be that if the value of the premises exceeds rupees 10,000, irrespective of the value of the suit, the city civil court can the suit can be entered only by not by the city civil court. Now, my lord, kindly take, my lord, the next statement. But that apart, my lord, without going, we may also rest our judgment on a simple basis, assuming the plaintiff could have valued the suit at rupees 1300 and odd, chose to value it according to the value of the premises. There was nothing in law to compel him to put a lower valuation and not higher. The value of the premises mentioned in the plaint cannot be said to be contrary, and the plaintiff is not obliged to put the 12 months rent value. In the present case, the plaintiff asserted the plaint, exactly like us, is asserted the plaint the value of the premises exceeds rupees 10,000. The plaintiff asserted in the written state suit was undervalued. If ought to have been valued of the amount of 1 year rent, the word undervalue is a mistake for the word of overvalue. The statement the plaintiff is squarely in accordance with law and not contrary to High Court was the proper forum. Then Mr. Chatterjee argued Mr. Chatterjee has placed reliance on section 5(2) of the Act. Subject to the provision of such and such, section 9 of the city civil court shall have jurisdiction. High Court shall not have to try a proceeding of civil nature not exceeding 10,000 rupees. The council said, according to the provision of the Act, city civil court have jurisdiction. The suit of civil nature which does not exceed rupees 10,000, there is no conflicting between the two acts. So, if this is the position today, and the division bench holds in respect of the case of Shivaji Mitra, where the rent was 850 rupees. It's a natural forum. You are a trespasser. I have a claim for mean profits where I have given indication in paragraph 19. This is the value of the suit property, and there will be 3.57 crores. Naturally, mean profits will be much more. It's a question relegated to the trial. Where is the question of interfering with the decree today? This is my submission on this. Now, kindly have division bench হয়ে গেল তো কোনটা Just the two sentence, I have more or less completed. This, my lord, unless it is set aside between the parties, my lord, it is in nature of res judicata. Kindly have a look at the Supreme Court, my lord. And even, my lord, it applies to execution proceedings because all findings are today, my lord, in my favor or the plaintiff's favor. This is, my lord, 2023 SCC online 1935, Justice Sanjay Kishan Kaul and Justice Sudhanshu Dhulia. Lordship will kindly take paragraph 20. Para 20. It was a section 47 case also involved. Kindly, my lord, takes it was submitted by the decree holder. It will be, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. 15 lines from the bottom, starting with it was submitted by the decree holder before the High Court that the order dated 12th of February has already attained finality and res judicata was applied to the judgment debtors. In support of the submission, the decree holder relied upon the decision of this court in such and such where the court reiterated that settled position of law that the principles of res judicata are not only applicable in respect of separate proceedings, but generally the principle of res judicata were applicable at the subsequent stage of the same proceedings. And therefore, the same court will be precluded to go in the question which has already been decided. Unless it is set aside, where is the question of reopening it and stopping a decree? Or deemed to have been decided at an earlier stage. It's not a question of deeming to have been because it's actually decided, these 3 points. In the other words, it would be barred by the principles of res judicata, at least by the principle of constructive res judicata. The logic is that the execution proceedings works in different stages. The logic is that the execution proceedings works in different stages. If the judgment debtor has failed to take an objection and have allowed the preliminary stage to come to an end, so he has taken an objection and preliminary stage has come to an end, the matter has to move to the next stage. The judgment debtor cannot raise the objection subsequently and revert back to an earlier stage of proceedings. So it's the case here, my lord, even in earlier stage of proceedings, like, my lord, the present stage where there is no section 47 on board, there was no application under Order 7, Rule 10, no application, my lord, under Section 11 of the Court Fees Act. This is subsequent stage and revert back to the earlier proceeding. This is exactly one of the reasons given by the executing court in the order dated 28th September, which has already been referred to, merely because it has not been specifically referred to the principle res judicata, it will not make any difference. Here, my lord, the point was presumed to have been waived. Here it was argued and waived. So where is the question of, my lord, arguing today, my lord, unless you comply with the appeals court order or get set aside the said order? Where is the question of the executing court being stalled by a person who has not complied the appeal court's order? And with this, my lord, I end my submissions. This is exactly, okay, a copy dao. Are other side pore dile hobe? Pore dile hobe? Acha, acha, acha. This is the division bench, my lord. What normally appears here, my lord, the words are peremptory. Here, my lord, it's more clarified. Kindly have a look at. It's from the website. Kindly take 1, 2, 3, 4. Third page, bottom paragraph. Paragraph at the bottom. In the event of default with complying with the aforesaid condition, the order of stay shall stand automatically vacated and the decree holder will be free to proceed with execution irrespective of the fact that the appeal is pending or not. Now, in our case, it's more categoric. In our case, it says, this is how the division bench will not expects a parties to comply their order, otherwise the consequence therefore. The consequence are, my lord, penal in nature. Like my lordship will know, my lord, when my lordship will is now my lord the interlocutory court now. Certain provisions of the act has to be complied with, like under the Companies Act, like the trademarks, or my lord Competition Act, or any other act which lordship will now come. Consequences are provided for it. If the consequences are penal in nature, these are mandatory. If it is not, there is no penalty provided for, it's directed. Lordship will, in our case, needless to mention that in the event of cost not paid, the appeal shall not be registered. The appeal is registered. In the event the amount as directed in the stay petition is not paid, decree holder shall be entitled to proceed with the execution of decree. The direction is peremptory. So even, my lord, I don't know whether extension will be granted at all. Normally, my lord, this is not stated. This is a peremptory directions. So where is the, he has argued, my lord, brilliantly, but first of all, there is no application. To hold a decree to be invalid, before 77, one should have a properly constituted suit. Today, between the same party, lordship knows where I am not showing, my lord, section 47, my lord, it's, my lord, between the same party fighting under the same decree or the representative, there should be substantive application of section 47. Read with section, my lord, 21, read with section order 21, rule 97 to 99 for registering a decree. So if that composite application, which is like a miscase in the court below, is not filed here, where is the question, my lord, of rendering by decree to be inexecutable? My execution, I am giving a, can it be said by decree is inexecutable? Can you hold so? In a plaint, of course, a plaintiff has to prove his case. In a plaint case, yes, you are adjudicating all the documents, my lords are doing so, and ultimately holds the plaintiff is not entitled to a decree. But where there is an adjudication and the decree, my lord, finds favor, the plaintiff, my lord, is in favor of the plaintiff. The decree finds favor of the court. Can it today be said, my lord, it's, my lord, inexecutable on a pecuniary jurisdiction, which is, my lord, the principle? Or, my lord, can it be said today that this provision of law applies, that provision doesn't apply? Lordship will kindly look at the schedule of the act. First of all, my lord, this provision of this act doesn't apply. Kindly have a look at, my lord, section 12A. I have given 2 stickers and, my lord, the schedule of the 1997 Act. Ache, Lordship, schedule. Yes, 12A. First of all, my lord, I have to only say the suit, my lord, exceeds rupees 10 lakhs. That's the Supreme Court, para 5. Here, my lord, this is a case, my lord, of, my lord, someone protected under the West Bengal Premises Tenancy Act. 12A, special provision regarding the jurisdiction of court for trial of the suit for possession. Notwithstanding 12 capital A, anything contained in law, a suit or proceedings landed against a tenant for recovery of the possession which the act applies, lies to a court set out in the Schedule 4 and no other court competent to try the suit. So, my lord, someone first has to be a protected tenant under section 2G of the act. Now, my lord, kindly take, my lord, schedule number 4. Previously, this was not the case. It was, my lord, overlapping. Lessee, licensee, tenant before the act. Kindly take, my lord, 4th schedule. Only one guiding factor. In case where the value of the suit exceeds rupees 10 lakhs to the High Court. This is construed by the Division Bench of Justice Girish Gupta. This is what you have to say. And relegation of mean profits. It is not a, I could have understood, my lord, in the 1956 Act, it was value of the suit and the market value. No. This, my lord, in the case value of the suit 10 lakhs, my lord, remains. And any event this act doesn't apply, my lord, he has not got protection of this particular act. He has not done so. And, my lord, only on the basis even of the jurisdiction, only on the basis of jurisdiction, my lord. Yes. Kindly, my lord, read, my lord. Pecuniary jurisdiction on mean profits of plaintiff cannot be returned, where mean profits have been claimed. on the basis of a valuation of the property. Kindly have a look at this is my lord, followed by our division bench. Well, I'm not saying 1987 3 Supreme Court cases 705. This is my lord, way back in 1987. There was an order 7 rule 10, the plaintiff was returned. First paragraph. Here there was nothing. The question involved in the case is whether the High Court of Calcutta was right in returning the plaint to be presented by the appellant for presentation of a proper court under Order 7, Rule 10 of the Code of Civil Procedure. Para 2. The appellant is the owner of flat number 2, now known as B, 4th floor Gem Building, Russell Street, Kolkata, so Park Street. The said premises has been leased out to the respondent the monthly rent of rupees 1400. The respondent has committed default in payment of rent. The appellant therefore served a notice under section 106 of the Transfer of Property Act and section 13(6) of the West Bengal Premises Act, determining the tenancy with expiry of the month and called upon to deliver possession of the premises. Now, previously, Lordship knows, my lord, notice were composite 106 read with, my lord, 13, my lord, section 13(6) of the West Bengal. Upon failure of the respondent to hand over vacant possession of the premises on expiry of January 1980, appellant filed a suit number 755 of 1985 on the original side of the High Court for recovery of possession of the premises and recovery of the area rent amounting to rupees 78,000 by way of mean profits, claiming mean profits at the rate of 7,800 from 1st February 19 until 30th November 1995. Now, my lord, kindly take paragraph 3. Any suit the value of which, Lordship finds this pillar from 1976, it's any suit the value of which is over rupees 1 lakh, now it's below 10 lakhs, had to be filed in the High Court in the original side. Accordingly, the plaintiff was present in the High Court after paying the necessary court fees on the basis of the valuation. After the respondent was served with the summons in the suit, he made an application before the court for taking the plaint off its file for return it to the appellant for filing the same in the proper court. The respondent stated in the application that on a plain reading of the definition of the expression tenant in the Act, the respondent continued to be a tenant after termination of his contractual tenancy and did not come to become an unauthorized occupation for accommodation. He was therefore liable to pay at the rate of rupees 1400 per month till the date of the suit. This was the argument. Now, kindly, my lord, takes me, lord, para 4. Section 4, section 15 of the code. Under section 15 of the code, every plaint should be instituted in the court of the lowest grade competent to try, and the value of the suit was rupees 4,200. Only it has to be filed in city civil court and not at the original side of the High Court. The principles regulate the pecuniary jurisdiction of the civil courts are well settled. Paragraph 4. Ordinarily, the valuation of the suit depends upon the reliefs claimed therein, and the plaintiff's valuation in the plaint determines in which it can be presented. So, valuation is on the plaintiff. It is also true the plaintiff cannot invoke the jurisdiction of court either by grossly valuing or undervaluing. The court always has the jurisdiction to prevent abuse the process. Under order Rule 10 of Order 7 of the plaint can be returned at any stage of the suit for presentation to the court in which the suit should have been instituted. Any stage of the suit. The stage of suit is over. There was no Order 7 Rule 11. This is exactly similar to Order 7 Rule 10. The question for controversy in this case whether the present case plaintiff has grossly overvalued the suit with the object of bringing it within the jurisdiction of High Court. When the suit is filed for recovery of money, the amount claim has been included to determine the value of the suit. In the instant case, the appellant has claimed a decree of rupees 78,000 for the period of such and such on the footing of the respondent's position unauthorized or illegal, he will liable to pay mean profits. The question whether the appellant would be entitled to a decree for mean profits at the rate of 7,000 per month or at any other rate after termination of tenancy is a matter which has been decided in suit. That part suit is pending. If ultimately it is found it is not entitled to get a mean profit for a subsequent period, she is entitled to receive rupees 1,400, the claim over and above, the question has to be, month will be dismissed. But the question whether whether she was entitled to claim mean profits or damage in respect for the period 1st April 19 could only be disposed of at the preliminary stage before the commence of trial. That question has to be decided conclusively at trial along with the issues raised in the plaint. The learned judge has returned a finding, given a decision. The suit in this court is maintainable. Having regard to some of the decisions of this reliance appellant in course of the appeal, we are of the view the matter is not free from doubt. The claim of mean profits is neither palpably absurd or imaginary. It needs judicial consideration. Mere acceptance of view to put forward by the respondent may lead to encouraging a tenant. This is most important. The encourager who has forfeited his right to tenancy to carry on dilatory tactics without compensating the landlord suitably for the loss suffered by him on account of unreasonable deprivation of the possession of the premises over a long period until he is able to get possession of the premises through the court. We cannot therefore state at this stage that the claim for mean profits have been made with good faith with the sole object of instituting the suit in the High Court of Calcutta, even though it has no jurisdiction to try it. Subsequent division bench clarifies, we do not agree with the submission made on behalf of the respondent that the appellant has dishonestly and intentionally inflated the value of the suit in order to infect the jurisdiction of a particular court which has no jurisdiction. In that ground, my lord, the application was dismissed and High Court was directed to continue with this suit. Exactly, my lord, this has been done on pecuniary jurisdiction. And after decree, my lord, it doesn't become void. If the court, my lord, otherwise, here it has a pecuniary, otherwise, my lord, if the court did not have any pecuniary jurisdiction. That is Justice S.B. Sinha's judgment, my lord, which in great detail has placed on the first date. The judgment name, I am not Subhash Mahadevan, the judgment. 2007 13 SCC that lordship has already taken note of. So, my lord, this is not a ground of an invalidity which goes to the root of the matter. It is not a case, my lord, this type of suit cannot be decided by the High Court or under its rules. In that context, my lord, when there is a strict non-compliance, I am entitled to proceed with the decree. If he complies, lordship can give you a chance to comply. If he has said that he is not in a position to comply. The consequence is, my lord, I am proceeding with the execution. I am entitled to recover, my lord, the possession, and a writ of khas possession, my lord, should be issued in favor of the plaintiff, my lord, in view of such non-compliance. Where is the bar? These are nice points of law. Well, appeal court will take care of, provided he complies. If he doesn't comply, I have shown the judgment, he has no right of hearing. So, my lord, these are my respectful submissions. These are my respectful submissions. Okay. Mr. Medula can argue now. It is a pleasure, my lord, arguing for the lunch.
So,
I'm back with it.
need some time.
Sometime. Monday, Tuesday, any day which suits your lordship.
Law points.
Yes,
Only
yes.
law
Only
points
law
and
points.
decrees.
Only law points.
No, he is that way, my lord, very fair.
Only law points. Absolutely. Any day, Monday, Tuesday. Tuesday preferable, but if it's not possible, I'm grateful for that.
The learned counsel for the decree holder has concluded his argument. Stop. The learned counsel for the opposite party decree holder judgment dater has sought for an accommodation for replying on points of law. Stop. This is the matter. 12 March. বারোটার সময় একটা এ আছে আর কি আছে তাই না পাসওয়ার্ড ওকে পাসওয়ার্ড
commercial course. Commercial division, pass over matter, item number 2.
Yes,
Lordship, Mr. Jishnu Chaudhary.
I can't hear.
Mr. Jishnu Chaudhary is on his legs, my
Not
lord.
today, good. Today.
Non-commercial চলে যাও। Original side matter, passover matter to be mentioned, item number 1.
On behalf of the petitioner, your lordship, petitioner propounded, your lordship. Your lordship, in terms of the last order, it was fixed on 15th of this month, your lordship. 15th of April, your lordship, at 2 p.m. for further cross-examination of the defendant's witness, your lordship. If your lordship can kindly fix it on 16th at 2 p.m.
Last order was passed by Justice Rao in court number 40. Matter has come from that court to this.
What do you want?
The
If you-
date of
date,
15th
your
April
lordship.
at 2 p.m. that be shifted to 16th April.
16th April.
15th April is Bengali Navavarsh.
Oh,
So that we all will have a.
there is
Might
no
be declared a
date
holiday.
mark. Here, the learned counsels for the parties have submitted that they, learned counsel of the parties have submitted before this court that the instant matter has been fixed for further cross-examination of whom?
Of defendant
None-
witness number.
Defendant's witness 1.
Of defendant's witness number 1 on 15th April 2024 at 2 p.m. Stop. They want that the said date be postponed to 16th April 2024. Stop. This is the matter on 16th April 2024 for further cross-examination of or witness action. Hearing witness action হবে or witness action or witness action.
For
At
witness
2
action.
p.m.
Your lordship, if your lordship is kindly be pleased to fix it at 2 p.m.
It is very much difficult for me because I have to attend division bench.
Yes, your lordship.
Tomorrow
That is
at 3 p.m. I have been
Because
Sign.
the person that all the witnesses they come in
only
the morning.
the witness.
I mean, they wait for the whole day. For those because of this, there is no certainty whether the matter will be called on or not.
exactly.
If your lordship
that.
kindly fixes money
That
for
what,
at least
it
the
will be
witness
a joint
actions.
Then they will come and again they will go back.
It is a kind lordship. Can
Yes,
be a
that
joint
is
witness
the
from the bar
only
that
thing.
in respect of witness action. Whenever lordship requires a witness to come,
If your
if a time is fixed, then it would be easier for all of us.
yes, your lordship,
12:15.
it would be very convenient.
At 12:15 goes in.
Grateful, your
12:15.
lordship. Grateful.
Item number 7, my lord, both all parties are here, also receiver is also here, my lord. And the first lordship,
receiver was present, but I am for the decree.
You have to call the list. I have a fixed matter, appellate side matter at 12 noon.
Your lordship, may I just submit? The problem is my problem is that I am the receiver. I'm in courts and sometimes I miss the matter because of that. I'll tell you
Just give me some time and I'll add it. Just
Item number 5.
Hey, next what ago?
Item number 6.
Yes.
My senior, Mr. Shiv Shankar Banerjee, asked for not today, sir.
Okay. Not
Item number 6 not today.
now 7.
Item number 7.
Your lordship, may I just
Sir, I am appearing for the decree holder.
Yes.
Your lordship, may I just submit? There was a direction long time back, around 10 years back, to keep 1,50,000 rupees in an account. At that time, they had an urgency. So I had a personal account which I was not operating. It was kept in that. It's an interest-bearing account. The problem was, I have the documents I've given to everybody, that there was already 10,000 rupees with my money which was there. Today, I inquired from the bank, there is 2,15,000 rupees in that account. I can
there is a direction to give the 2,10,000 rupees, but the amount which they are entitled to is around 2,05,000, not 2,15,000 or 10,000. So your lordship, only that much. If that alteration is done, then I can transfer. And another thing is, their client, whom I have to give the money, whether you have been given opportunity to keep the amount in your.
If your lordship kindly come to my lord, the amount is a collection from the rent.
No.
This is the partition property. This is all the collection from the rent.
Your lordship, there is no collection from the rent at all. May I just explain? Can you file an application? May I just, your lordship, may I just tell this? This is not correct. There no because this has been like for 12 years. This is going on. This entire thing is going on. I have no help from anybody, and I am getting harassed because of this matter. What happened was, I'll tell you what happened. There were properties which included a lot of people who were going to pay 50 rupees rent, 5 rupees rent, or something, whatever there. Nobody has a list. I was never told to collect. I was told to, but there was no chance of collection because nobody has a list of who are these tenants in these small properties all over the slums and all the other places. I have no idea. Now, what this money is not from collection of rent. The plaintiff there, they had put in 1,50,000. There was an apartment which was to be partitioned, and there was supposed to be your lordship, construction, I think, if I'm not mistaken, of a toilet. And for that, 1,50,000 rupees was to be paid by one party to the another. That 1,50,000 rupees, there was a direction of court to keep with me.
Let him submit the report, my lord. All clarification will
I wanted to something very simple. The directions which they have asked for is also, there is other aspect of this direction. So I want to go through those directions. What are the directions? Maybe, your lordship, one more thing. What happens is, their principal, Sanderson Morgan, who representing the person who had given that 1,50,000 rupees, and that's their, they are asking for that money back. I have no problem. It's their money. They can take the money. That 10,000 rupees is my money, which is there in the accounts. Other than then, they can take anything money. I have no problem with it. But the problem is, I cannot give it to their clients because they are foreigners. Yes. I will be held under RBI guidelines, remittance guidelines. Yes. I cannot transfer money like that. Yes. I can transfer, your lordship, the entire money to Sanderson Morgan.
We have no objection, madam.
They have no objection. I can transfer it to them or advocate on record.
Yes, madam. We have the decree holder. We have the advocate.
You can give it to advocate on record. Yes, your lordship. I will. You can ask the pass that order. Okay. I have to go through the entire record. Yes. Will you kindly file a report or short report? Yes. Your lordship, those are like, I have to trace years of orders. They have to pay your remuneration. I have to consider the remuneration also. Okay.
And one thing, my lord,
you are my officers. Please file a report to assist me. Okay, very well, your lordship. I'll file it. 7 days? Yes. Your lordship will not give me 7 days. Give me 2 weeks time. I'll file because I have to trace it, all the orders. Okay. Very well.
And my lord, in the meantime, my lord, in the meantime, the judgment data
has died, my lord. We have to make an application for.
You will reflect that you are directed to file the application for substitution.
We are making that.
So they are seeking for the 2 weeks time. That will.
Who is the decree holder?
I am for the decree holder, my lord.
Okay. The learned counsel for the parties have submitted that necessary steps are to be taken for bringing the legal heirs of Mrs. Hajra Parveen.
I have furnished all the particulars.
Yes, my lord, we have.
Since deceased, and for that reason, they have sought for an accommodation. Stop. Para. The learned receiver is present. He is to file a short report for assisting this court to give further direction over the matter. Stop. Please the matter. কত হচ্ছে 19 March.
Your Lordship, just only one thing. Your Lordship, just rather look at the 21st December order.
21st December.
That's where the directions were passed.
21st December of 2023.
23, Your Lordship. There was a direction.
Yes, receiver is directed to disburse a sum of rupees.
Yes, the problem which I faced immediately was that account, because for 10 years it had not been operated.
Okay.
So only to that extent. Your Lordship.
The receiver is directed to disburse, is directed to submit his report before he complies with the direction contained in 21st December 2000. I have kept the order in abeyance, in fact. Okay, you come back. Come back with the sorting.
I have already furnished the details of
Okay.
details of the
So, the learned counsel for the judgment debtor has submitted that he has already intimated the particulars of the legal heirs of
My lord. Yes, we have already.
লিখে রাখেন কোথাও একটা, ঠিক আছে? Okay.
my lord, report should be given to all the parties.
I will obviously give it, Your Lordship.
Everything need not be recorded. Okay. এই ডাকো, কেউ এসছে? বলে দাও, আমরা ডেকে নিই স্যার আর কি। কেউ এসেছিলেন দেখো। Appellate side matter. Is anybody present in respect of appellate side matter? নেই। ওটা জানিয়ে দাও।
হ্যাঁ জানাচ্ছি, বলছি। আইটেম নাম্বার 8,
Yes.
This
Item
is my
number 8.
application.
I appeal for the decree holder.
For the
Decree holder.
My learned friend appears for the decree holder, my lord. I appear for the purported judgment debtor number 1. I am resisting the enforcement of this decree in India, my lord.
What is the decree about?
This is a decree for payment of money made by a court in Sharjah, United Arab Emirates.
Yes.
Ex parte decree.
Affirmed by the appeal court in Sharjah.
Oh,
Trial court dismissed. Actually, my learned friend must state the full pack. It seems the trial court dismissed.
And dismissed. The trial court said that you cannot file it in personal capacity, but the decree was granted. From that, I preferred an appeal. The appeal court says that he's
Even an ex parte proceedings did not succeed. He had to file an appeal. Long and short of it.
being an executing court,
You are
I
not
cannot
stating the correct fact, Mr.
go
Thakkar.
beyond the decree passed by the Indian courts. How can I go beyond the decree?
So I'm not my lord, I'm not addressing your lordship on the merits.
Okay, yes, certainly.
I am not addressing your lordship on the merits. I'm just telling your lordship what the decree is about.
Appeal court, I had to go only because the trial court said that I cannot proceed
Yes,
on personal capacity. Only for changing that, there was a modification granted. The amount was increased by the appeal court.
Now, today is fixed for what? Have you filed any application?
Yes.
47.
Yes, my lord.
What number?
No, this is GA1.
GA1. Yes. You can start.
May I start, my lord?
Yes.
My lord, I have twofold objections to the executability of this decree in India, my lord.
Q180 2023 IAGA. Yes. You have twofold.
I have twofold objections, my lord. One,
JD.
yes, my lord. First objection is that I was not given any notice of the proceedings.
First of all, that
No, I was
no notice
of the proceedings or of the suit which culminated, my lord, in the decree, appellate decree, which is sought to be executed. No notice of the suit, no notice of the appeal.
you are residing where?
I am residing in Calcutta. Suit is filed, my lord, in Sharjah, United Arab Emirates.
Yes.
Now, my lord, I have no notice of either the suit or the appeal. Both. I have no notice because what is being sought to be executed before your lordship is, my lord, the appellate decree. So no notice of suit, no notice of appeal. And therefore, this is a decree which is made in violation of the principle.
They have to consider the procedures being followed in Sharjah.
Well, that is for him to satisfy your lordship. All that I need to satisfy your lordship is,
If expiry decree is passed, then I do not know what is the law there. Whether again, who filed the appeal?
who filed? Appeal, he filed.
Yes, right.
Plaintiff.
So expiry decree was passed in his
Expiry
favor.
decree, your lordship, notice was served, they have not appeared. That I have discussed.
My question is, expiry decree was passed by trial court. Who filed the appeal?
He filed the appeal. He was.
Just 1 minute.
Yes, yes.
Trial court said that I cannot proceed in my personal capacity because my claim was twofold. I filed the suit on behalf of my company as well as I was a party in my personal capacity. The trial court said that you cannot proceed in personal capacity. I went up in appeal. The appeal court has just modified the decree saying that you can also proceed in personal.
So this is not the decree. Expiry decree was not in favor. That means that suit was dismissed.
No, it was not dismissed at all. Decree was passed.
And first trial court.
Decree was passed in my favor.
What decree?
Monetary decree, your lordship.
But then why you have moved the appeal court?
Because the trial court said that I cannot proceed in my personal capacity because I have included myself not only as a person, but I have also included the company on behalf of which the investment was made. It stands today that the appeal court decree is there. It is affirmed the trial court decree.
Yes, he has admitted that.
And it is not an ex parte decree, your lordship. We have proof of service to show that they have been served, they have not appeared.
It is not expiry degree.
No. They have not appeared.
It is expiry degree.
Expiry degree means undefended.
But notice was served.
Undefended.
Undefended.
They have chosen not to contest.
Yes, you can say so.
Correct.
Yes, first point is no notice. Second point?
So the first point is no notice. And the second point is this, my lord, that the decree was made when the proceedings were barred under the provisions of the Insolvency and Bankruptcy Code. Of the, my lord, there is.
Of which code? Of which country?
Of our country.
Second point is the proceedings.
Proceedings were instituted when there is a moratorium on proceedings, on any proceedings under the provisions of the Insolvency and Bankruptcy Code.
Yes.
And the decree which was made is therefore nullity.
Moratorium.
Yes.
So decree is a nullity.
Decree is a nullity. Now, my lord, may I satisfy your lordship first on violation of natural justice by non-service of decree upon me. May I deal with the factual part first and then come to the legal argument on nullity. Your lordship kindly has, my lord, there is no dispute that this is a reciprocating country. My lord, United Arab Emirates is a reciprocating country. There is no dispute about that. So therefore, he is entitled to execute the decree in the Indian court. The execution is provided for, my lord, under section 44A of the Civil Procedure Code, read with section 13 of the Civil Procedure Code. 44A and 13.
Well, the decree of this Indian code can be implemented there.
Yes.
By virtue of which section?
Well, that is, they would have some reciprocal provision in their United Arab Emirates law. So, my lord, what happens is the countries enter into treaties by which they agree to recognize decrees of each other's superior courts. So, by virtue of the
Ministry of Law and Justice.
Yes.
I have recently find a prayer from that decree is to be executed in the court of Dubai, but one treaty was filed before me.
Yes.
I have gone that. I have gone through that treaty. But the provision is not there that our decree can be executed there.
So, my lord, that
Foreign decree can be executed here.
so that provision, my lord, your lordship will have to see, or somebody, the petitioner would have to show your lordship that provision in the Dubai law, because that the acceptance is in Dubai. Like we are accepting, my lord, the foreign decree in Indian law. Therefore, Indian law provides the provision in 44A. Similarly, because of the treaty, the law of the United Arab Emirates, my lord, would have somewhat a similar provision. Yes. So that your lordship would have to be shown the UAE law. Now, my lord, kindly come to 44A once, please, my lord.
Yes.
May I please 44A, please, my lord? Where a certified copy of a decree of any of the superior courts of any reciprocating territory has been filed in a district court, the decree may be executed in India as if it had been passed by the district court. So, our first essential ingredient is that there should be a certified copy of a decree. I'll show your lordship, my lord, whether this is a certified copy of a decree or not. Whether he has filed even a certified copy of a decree to be proceeded with. Now, my lord, kindly see, together with the certified copy of the decree, shall be filed a certificate from such superior court stating the extent, if any, to which the decree has been certified or adjusted, and such certificate shall, for the purposes of proceedings under this section, be conclusive proof of the extent of satisfaction or adjustment. So, my lord, along with the application for execution before your lordship, my lord, he has to give a certificate from the court which made the decree whether any part of recovery has been made or not made. Your lordship will not find any such certificate in this proceeding.
Certified copy of the decree is there.
Certified copy of the decree is also not there. There is no certified copy of decree. What is there is an English translation. We don't know what is the translation. I am not competent in, my lord, the Persian language or Arabic language, whatever.
Certificate is also there.
Yes, certificate copy.
Translation, yes, your lordship, the originals are filed with the
certificate copy is there.
Lordship, kindly come to my execution application.
So your
No, I'll complete, my lord. So this is a yes.
certified copy has been submitted.
Yes, with
I'll show your lordship. Yes, I'll show your lordship what is the copy and what is the translation, because it is in the local language. Now, unless it's an official translation, I don't know whether this is a certified copy or what copy this is. The translation also has to be official.
Yes.
The translation has to be official. There is no official translation. It is from some translation site. Yes. Yes, app or some office over there who's doing translation. Palmyra Legal Services.
Yes.
If there's a translation, we have a department in court who does the translation. Your lordships don't act. If I have a translation to be done in French language, I will not go to Ramakrishna Mission and get it translated from French to English and give it to your lawyer. That will not be acceptable. Yes. It has to be by an official translator.
Okay.
Palmyra Legal Services. I don't know. He has to show that this is the official translating body of the state of UAE. But more than that, my lord, your lordship sees it has to be certified copy of decree. Now, what he says is certified copy. I don't understand because I don't know Persian.
No, to solve this, to cut short this matter, I think that if it is not official translator or
not official,
then we can give them some time to bring. Can it be possible?
Possible. Then he has to rectify the defect.
Yes.
Is the defective execution application on
this point only? Well, official translator.
Lordship, because Lordship, my learned friend has not
Moira or something like that.
Palmyra.
Lordship, kindly see that if Lordship is not satisfied with this, then I'll again take a certificate from the concerned.
Kindly see the certificate which is
courts our
kindly
is
see
very
Lordship,
much
page 3093 onwards, the originals have been filed.
Whether this is the official translator.
Kindly come to page 49. Your lordship will see the English translation. Because the Arabic, I don't want to trouble your lordship with.
Persian is Greek to us, English is also Greek to them.
Correct, but it has to be done by somebody who's authorized.
No Persian. So English is
They
Greek
will
to
arrange.
UAE.
Kindly come to page 17.
Kindly see, Lordship.
17 is the decree of the trial court. 17.
17.
17. Yes.
17, yes.
This is the decree. This purports to be the official English translation of the judgment of the first court. Your lordship sees this is from some on time legal translation. On time legal translation. This is not the official body.
Up to 41. The certificate.
41.
Yes, Lordship. This is the certificate. Signed and stamped by Ministry of Justice. Lordship, again, these certificates, kindly see, apostilled by Anita Gupta, Vice Consul, Consulate General of India, Dubai. Now comes the original decree at page 42 in Persian language, in Arabic.
This disclaimer. No
And Lordship, these points have not been taken up in their application.
My lord, he has to satisfy your lordship these points first.
You have not taken this point.
And when my learned
veracity of the judgment.
when my learned friend says 2.
Yes, your lordship.
Yes.
Original.
Original. Ministry of Justice.
Lordship.
But the
Language is, lordship, alien to us.
Yes.
Now, lordship, the second at page 49 is the appeal court's order. Federal court's order. In appeal, again it begins, lordship, the translation. The original begins at page 69.
Well, let us.
69. Yes, your lordship. This is the original copy. The translated copy, your lordship, has produced at page 49. This is the original certified copy of the decree.
the amount of money has been written in English. Amount of money.
Well, then, friends, clients have been suffering 3,000 crores decree dues in NCA.
1,000.
Nearly. I am only 189 crores.
So I want to point it out to you that it may cause some difficulty,
lordship,
at the time of adjudication or
lordship,
at the time of disposal. So
I'll obtain another certificate saying that this is the original, because I have to again
I do not know.
Sharjah. Now, this
That
point
is
has
his
not
choice.
been taken.
Yes,
This point has not been taken. He has not challenged the
required to
veracity.
without wasting the court's valuable time, I have
He has
requested
not
you.
challenged the veracity. He simply says he has not been served ex parte.
Now he is.
No, his application, the face of it is not
I'm
maintainable.
asking this question.
No, lordship.
Leave it.
No,
I am
lordship.
asking you.
No,
You have to satisfy me.
I'll do that, lordship. I'll get a certificate if your lordship wishes. I'll get a
So come
certificate
back
from
with
Sharjah.
There's no question
come
of
back with
wishing.
proper
He has to
certificate and
satisfy.
everything.
Now, this point was never taken. Now your lordship has directing me. I'll do that.
I have to pass order.
Absolutely, lordship.
So you.
Lordship, 3 weeks because Sharjah.
Okay, yes. The learned counsel
Both
for
the judgments I'll get, lordship.
learned counsel for the decree holder has sought for an accommodation for bringing the for bringing the certificate as required under section 44A 2 of the Civil Procedure Code in connection with the judgment and decree passed by the Honorable Court, whether High Court or
The federal court and court, both. One is federal court, is the appeal court, and another
the Honorable Court
at Sharjah, lordship.
at Sharjah. Stop. The learned counsel for the judgment debtor has submitted that he has no objection if the defect, if any, is remedied in the meantime. Stop. This is the matter after 3 weeks at a time.
Lordship kindly makes 4 weeks.
Yes. What are 4 weeks?
Grateful, lordship.
Unless the records are ordered, my lord, it
Yes.
is difficult.
It will ultimately it will wastage of
Yes.
valuable time.
That's why I said, my lord, if
Valuable
this
time
is,
of the learned advocate.
and if this is dismissed, he'll file a second. So there's no
Kindly
point,
see
my
that
lord.
prayers in their application: dismissal, transfer, and stay. All 3 prayers made. So he knew that it cannot be dismissed, it cannot be transferred. Only at best can be stayed.
Okay, you bring
Grateful, my lord.
certificate to my satisfaction.
Lordship.
Grateful, my lord.
Yes. বাকি আছে এখন
Examination of judgment debtor, item number 9.
judgment
The
date.
decree holder, my lordship, Miss Resmi
Can't
goes,
hear you.
Miss Resmi goes appearing to the decree holder, my lordship, due to some personal difficulty. She not into the court, my lord.
What is that?
My lord, that matter where the jurisdiction has been challenged, my learned senior friend was arguing, replying, but today she is not there. My lord, kindly fix it on 7th on that day. Well,
7th.
The learned counsel for the decree holder has sought for an accommodation as her learned senior counsel is not available. Stop. Please the matter after 7 days.
No, 7th March.
7th March.
Please the matter on 7th March.
New motion, item number 10.
My lord, I appear for the executor.
I appear for the one of the legal heir, your lordship. Your lordship, in this matter, there is one point is being left to adjudicate in this matter, for which I will be praying for not this week, your lordship, on the ground, because my client is traveling and we have to take instruction.
Appearing on behalf of whom?
One of the legal heir.
One of the legal heir.
One of the legal heir or one of the beneficiary.
My lord, I had filed the probate
What is the
petition.
name?
Rajiv Jindal.
Rajiv Jain.
Rajiv Jindal.
Yes.
My lord, I appear for the executor. My lord, this is in respect of the will of Mrs. Kamla Jindal. My lord, he is one son and the other son is with me. I am the executor. Now, my lord, probate was granted on 19th of February 2021. Now, post grant of probate, my learned friend has filed the application for removal of the executor. But I was opposing the application, affidavits are complete. Now, my lord, what has happened is the only objection or the only ground that he has canvassed in terms whereof I should be removed and I should not continue with the discharge of estate of the deceased is that, my lord, expenses have been incurred from the estate. My lord, that is his only ground. Why lawyers have been paid from the estate? Well, this is a misconceived objection. The reason is the will of the deceased itself provides that after meeting all the legal expenses, the estate or whatever amounts or assets or properties are left in the estate, that will be distributed amongst the heirs. But she left behind, husband died. Now she left behind two sons, Rajiv Jindal and Sanjeev Jindal. He is appearing for Rajiv Jindal. Now he is the troublemaker.
Yes.
Sanjeev Jindal is with me. Sanjeev Jindal is saying that yes, whatever it is, you finish off the expenses and distribute the estate. Now, my lord, post grant of probate, my lord, he has applied for removal of the executor. Now, my lord, wherever, now, my lord, this proceeding, though probate was granted in February 2021, this is the third year, 2024, that, my lord, this application is pending. Lawyers are appearing. Expenses are being incurred, and this is the only ground as to why the estate is being.
Judges are also hearing.
I'm sorry, my lord.
Judges, honorable judges are also hearing your cases.
Yes,
but in
my lord,
spite
if
of
he had
that,
not filed the application, then, my lord, the process
just a minute. When? Sir,
Not this week, your lordship. On
not
coming
this as Monday.
Monday.
Okay. We shall
Only
finish it.
one issue is left, your lordship. As my learned senior friend has already pointed out, there is a litigation cost of 20 lakhs, odd amount of 20 lakhs for a PLA matter. So, your lordship, we have to, we will give our submissions on that, whether 20 lakhs is the justifiable amount.
But I'll
for a
just answer
probate
the
application.
issue.
The learned counsel's fees, 20
Your
lakhs.
lordship,
is a very
that we will
meager amount. And the rate of the learned counsels of the Calcutta High Court is very low.
Is that, I understand. So we will submit. I am
very meager. It's very meager. So
we will submit.
My lord, only one indulgence. My lord, on the last occasion, when the matter appeared before the coordinate bench, my lord, we had handed over a check of worth rupees 30 lakhs in favor of my learned friend's client.
It has been recorded there. Yes.
Yes.
So
now, my lord, my learned friend still is saying that he has some objections so far as the expenses that I have incurred from the estate, so far as litigation cost is concerned. My lordship would kindly direct my learned friend to give us a list of objections such that I can deal with the objections and this matter can be put to rest.
Still, lordship, only one
No,
point.
it's high
No
time, my lord,
further,
February
no,
2020
no
is gone.
further affidavit or anything is required, your lordship. We will finish it off on the next date fixed in one hearing itself.
okay.
No
Just
objection,
give-
no further.
Just give 1 day time.
Yes.
The learned counsel for the legal heirs, Mr. Rajiv Jindal, has sought for an accommodation. Stop. The learned counsel for the executor has raised strong objection. Stop. List the matter on Monday, 11th March, for hearing of the petition submitted by Mr. Rajiv Jindal as a last chance. Okay.
Yes,
Deeply obliged, Your Lordship.
last chance.
Yes.
New chamber application item number 11.
My lord, I'm for the petitioner, my lord. I'm praying for an adjournment. My lord, kindly fix the matter on Thursday, my lord.
Hon'ble. The learned counsel for the petitioner has sought for an accommodation. Hon'ble. Learned counsel for the petitioner has sought for an accommodation. Is the matter? 7th March.
Much obliged.
Item 11. Item number 12.
Application has been filed, Lord, for making an inventory of locker, Lord.
When this was filed? What is the status? Are you executor or Riddhiman Roy?
Yes.
Oh yes, I have heard this one.
Yes, Lord. 12th June, Lord, it's been.
Yes. You are not legatees. Are you beneficiaries? Are you one of the beneficiaries?
One of the beneficiaries, Lord. And Lord, here, Lord, court officers should be appointed, Lord.
Yes.
In his presence, Lord, the locker is to be opened. In the presence of the bank manager, Lord, and whatever necessary.
Without notice to the other beneficiaries. I want to know. I want to know the process from you. Without notice to other beneficiaries.
Lord, notices have already been issued.
No. I want that this matter will be, the locker will be open in presence of all the beneficiaries.
Lord, court officer can be appointed, Lord. Inventory can be made and the list can be prepared, Lord.
Who will pay the charges? Who will pay the charges for the court officers? That means receivers.
At this stage, Lord, we can pay the charges, Lord, and that after that, Lord, it can be adjusted from the estate, Lord.
Oh, I see. Which bank?
State Bank of India, Mankundu branch, Lord. And there are two lockers, Lord.
There are two lockers.
Yeah. State Bank of India, Mankundu branch, and UCO Bank.
And who are the other beneficiaries?
Lord, they are the daughters of the deceased, Lord.
Who died? Prabir Kumar Rai.
Prabir Kumar Rai. Daughter of Prabir Kumar Rai.
And he has one son or two sons?
One son.
One son and two daughters.
One son, two daughters. Wife is alive.
And wife is also there. So who are the beneficiaries? One son and two daughters, or everybody?
Son died, Lord. Son, grandson, he is the beneficiary.
Oh, grandson is the beneficiary.
He has applied for the letter of administration.
So probate deed is in sorry, not deed. That is the will.
Yes.
In the will, who was the beneficiaries? Only one?
Lord, there are. If your lordship kindly looks at the will, Lord.
Hey, will da dao to?
Yeah. Page 2, Lord.
Yes.
Here he has bequeathed the.
Yes, please read if possible.
I give rupees 1 lakh each to the following grandsons and daughters. Vikriman Rai, that is son of Dhruvajyoti Rai. Dhruvajyoti is the son of the deceased, not Sinjini Rai and Shreya Rai, both daughters of Shomir
Kumar Laik,
Shomir Ruman Rai. Annesha De, Sohan De, daughter and sons of Vivek De. I give rupees 3 lakhs each to the following. Pushpita Laik, wife of Shomir Laik. Ranjita De, wife of Vivek De. Devashri Rai, wife of Dhruvajyoti Rai. And Valentina Mukherjee, my dearest Bhagni. My son Dhruvajyoti Rai will get the following. Subsequently, he has died, not predeceased. And thereafter, not. So this is how he has bequeathed the property, not. And
Dwelling
affidavit
house.
of assets we have already filed, not.
A dwelling house at Asirvad,
Yes, Lord.
Altara, Mankundu, my share revolved, my share of dwelling house.
My share of Sumangal marriage house situated at Hooghly. After disbursement, as per the detail in page 2, the remaining money available in SBI account of SBI Mankundu and UCO Shaurafuli Axis Chandanagar and all FDs mutual funds, etc. Before I conclude, your mother is a simple, demandless lady who loved the nature and not the earthly belonging. She wanted to stay in the village like ours and with full of trees and flowers. My request is do not cut the tree in the house, which will carry the memory of your mother.
In which paragraph the locker has been mentioned?
আমাদের যেটা না সব চলে গেছে পুরো প্লেসে পুরো প্লেস
But here in paragraph 6, page 4, Mlot,
yes.
After disbursement as per detail in page 2, the remaining money available in SBI account of SBI Mankundu, UCO Bank, Saurafuli, Axis Bank, Chandanagar, and all FDs, mutual funds, amount, etc. Here, nothing has specifically has been.
In locker money is not kept.
No, locker has specifically has not been stated. But we have found out that there are two lockers.
Who is senior? You are he. He is submitting. Allow him to submit. Okay, where is the mention of specific mention of
all property.
whatever you do? There is no
Sorry, my lord.
there is no mention of locker in the will.
But my lord, all movable and immovable all movable and immovable. Both the movable and immovable properties after my death.
The will starts at page 2. This is the will regarding the share of my available cash, kind, properties, both movable and immovable, after my death and the death of my wife, Srimati Shefali Rai, aged 70 years, amongst my legal years. I give bequeath.
No, I do not find in that there are two lockers in the plans.
Not speaking.
So,
neither the FDs but if your lordship kindly looks at the.
we can seek for a report from the concerned bank.
Yes, yes, no. That
Yes.
your lordship.
In whose name these lockers are there? File an affidavit. Seeking paying. Allow,
we have already stated in the affidavit of assets.
Where?
Yes, asset.
Can we see, Lord, we have annexed it.
Asset wait na. It asset. It asset.
Annexure B, Lord.
Annexure B.
Page 6.
Page 6.
Last tag by lost.
Yes.
Kindly, page 10, Lord.
এটা কি দিলে ও
Yes,
অ্যাসেটস দিয়েছো পেজ 10 তো আছে পেজ 10 তো নেই এখানে
GA1, Lord.
G1.
GA1.
Yes.
GA1 টা
আরেকবার বলুন, মানে উইলেও আছে উল্লেখ করা, উইলেও আছে,
GA1.
উইলেও উল্লেখ করা আছে লকের কথা।
Page 10.
G1 মেনশন নেই,
Page 10.
আচ্ছা,
Yes.
আচ্ছা, আচ্ছা।
Yes, page
এখানে
10.
আছে উল্লেখটা আছে।
Locker number such and such. Not known. What not known? Oh, the contents. Yes, locker number such and such.
Content is not known, Lord. That is,
Yes.
we wanted to know the content, Lord, by way of.
নেক্সট পেজ আরেকটা আছে, নেক্সট পেজ আরেকটা আছে, আরেকটা আছে
Now,
এটা নট নোট।
And another, Lord.
but
Please,
as
you
there
go
is
back.
no whisper in the will
Yes,
regarding
madam.
locker,
Yes, madam, there is a whisper.
mention of locker number.
Yes, madam. Yes,
Locker
madam.
number.
Also, yes, madam.
Please,
72
please.
by 2, madam. Madam, page, last page, madam.
Please.
Last page in my handwritten, madam.
Last page,
Madam.
page number 14 here.
Yes, Lord. Page 5, Lord.
Page
Second,
in my
second
will.
last page.
Handwritten will, madam.
Oh, I have asked. Yes. Where?
UCO Bank locker number 72 by 2. And another, madam.
Actions after my death, Lord.
Then please read.
To inform IOC as early as possible to settle mother's share. Then, Lord, 3 to contact the following person. Lord, kindly come to 4. Papers related to the house taxes are kept in separate files. One omission in the will I am giving below. The ownership of my car. And prior to that, Lord, C. All related files are available in my room. Search and find out UCO locker number 72 by 2.
UCO locker number 72 by 6. The one locker and another.
One locker.
Another locker.
Another locker not
One locker is mentioned. Another one is not mentioned.
Come back
There
with,
are 2 lockers, Lord. We have
maybe. So come back with some application or something like that. I think.
But
Will
we
help.
have stated here, Lord.
supplement affidavit.
Only one locker. Then I can give.
Yes,
Allow
but in the
this.
affidavit of assets, we have mentioned 2 lockers.
That I know, but then I have to take a report from the concerned bank whether this locker belongs to you or not.
The bank, your lordship can ask for call for a report, Lord.
The learned counsel for the petitioner, propounder. No, petitioner, propounder. Petitioner has submitted that inventory in respect of 2 lockers mentioned in page number 6 and 7 are required to be made. The affidavit of assets at page 6 and 7 of the affidavit of assets are required to be inventorized. INVENTORICD সম্ভবত ঠিক আছে দেখে নেব এটাই তো বলছি in presence of the court officers. Stop. Para. I have gone through the will. Find that. So there is a mention of UCO Bank account, UCO Bank locker number 72 by 2. Just 72 by 2. I do not find any mention of the other locker, that is locker number 2/24/34 lying at State Bank of India, Mankundu branch, 53 JC Khan Road, district Hooghly, pin code হচ্ছে 712139. Stop. In view of the above, the manager, State Bank of India, Mankundu branch, their address লিখে দেবেন 53 is requested to submit a report as to whether the locker number 2 by 24 by 34 in his branch is lying in the name of, what is the name of the deceased?
Probir Kumar
Probir
Rai.
Kumar ji.
Probir Kumar De
Ray. Rai, my lord.
Probir
R-A-Y.
Kumar Rai. R-A-Y, na?
Yes, my lord.
Probir Kumar Rai. Stop. আচ্ছা একটা স্টপ না দিয়ে কমা by 15 days time will you have একটা 15 দিনের ডেট কবে হবে?
বলেছি 19th March.
19th March. By 19th March. Stop. This the matter. On 19th March, stop. The learned advocate of the petitioner is to request, it is requested, learned advocate of the petitioner is requested to communicate this order to the manager of the aforesaid bank. Stop. এটাও লিখে দিচ্ছি, ঠিক আছে? কোনো বুঝতে অসুবিধা হলে বলুন, কারণ অনেক আটকে গেছে।
Deep level.
হ্যাঁ।
For hearing, item number 13.
Item 13, my lord, this is my application GA4. Last occasion that application was not available on file.
Yes.
I do not know if
Are
your
you still-
lordship officer is talking. My lord, this application is for appointment of an administrator pendente light.
Yes.
Essentially, I am challenging the executor's handling of the estate. It is my allegation that the executor has undervalued the estate in his affidavit of assets and has not given the true and correct picture of the assets and is making use of the deciphering away the estate and thus enriching himself at the cost of the estate. Thus, I'm asking for the appointment of an administrator pendente light.
Yes.
And in injunction
Now,
over a locker.
who will be appointed as administrator in pendente light and advocate? of
That
this
is, I leave it to
advocate of this court.
I leave it to your lordship's discretion of that.
Remuneration? How the remuneration will be paid? Who will pay?
My lord, that is the
Pay not, will pay.
no, my lordship will determine that of course. It is the discretion of the court, my lord. I cannot possibly insist.
Who will pay?
My lord, the parties will bear, the estate will bear.
Yes.
The estate will bear.
What should be the remuneration?
Lordship,
Suggestion.
lordship, I cannot possibly say. I can't possibly say, my lord.
So this is your contention.
This is my contention, my lord. This is.
They are.
I'm opposing him.
You are opposing?
Yes.
Have you submitted any
Yes.
affidavit in
Filed,
opposition?
Affidavit of opposition has been filed long back, my lord.
You have completed your submission.
My lord, the entire point is that this is, he has not given a true picture of the assets. Several jewelries lying in the locker had not been disclosed at all in the affidavit of assets, and injunction had been granted by the coordinate bench on the locker, which was.
Whose estate is?
This is my the estate of Suresh Tibrewal. The executor is my brother, Ingit Tibrewal. ইনজাংশনটা গ্রান্ট হয়েছিল অর্ডার
Ingit Tibrewal.
ভোজনাগরওয়ালা নি Tibrewal. She is a sister.
Tibrewal.
Yes.
Wife of?
Rishabh Bhojnagarwala.
Oh, I see the brother and sister.
Brother and sister, my lord.
Yes, brother and sister. Okay. Now, what happened? He has not disclosed everything in his affidavit of assets.
He's not given a lot of details are missing, including shares of the shares held by the deceased. None of that has been disclosed. The jewelry.
How you will come to know about the contents of jewelries in the locker?
It was known to me. As a daughter of the deceased, I knew that such locker existed and several jewelry was there. That is the thing. This was known to me. This has been deliberately suppressed by the executor in order to siphon away such jewelry.
What would be the function of administrator?
Not only to find out the entire extent of the estate, but also to administer it to prevent.
Have you mentioned
siphon.
anything? Please read out where you have mentioned for which you are wanting to appoint one administrator pending.
Appendix C is my application. Para 6 and 7.
Para 6 and 7. Yes.
Para 8.
Para 8.
Para 8 onwards, I have given the details as to what has been suppressed by the executor.
Yes, please read.
Large number of gold and silver jewelry and items disclosed in the income tax file of the deceased has been removed or illegally taken away. Deceased owned a locker at Punjab National Bank in which are kept large number of gold and diamond jewelry belonging to the deceased, but no mention of such locker has been made in the affidavit of assets. The deponent is the owner of undivided 1/4 share in the Hindu undivided family as per the latest amendments to the Hindu Succession Act. And upon the demise of the deceased, the share of the deponent stands at undivided 1/3 share. But the sole executor is trying to hide and suppress the details of the assets and properties of the HUF in which the deceased had a share. The deponent states that totally misleading and incomplete mention has been made in order to divert the assets and funds in the guise of being sole executor of the assets of the deceased. Deceased had vital interests and shareholdings in his name in several foreign companies at Kuala Lumpur, Malaysia, which have been tactfully kept outside the purview of the probate application, so that the purported sole executor could later on liquidate the same and siphon away the proceeds. The purported sole executor has not intimated the banks where the deceased had bank accounts and fixed deposits, and also the locker, as stated above, and the depositant has valid reasons to believe the said sole executor has been regularly visiting the bank branches, and by taking advantage of the power of attorney, which was given to him earlier when the deceased was alive, is removing and depleting the money and jewelry regularly, thus amounting to theft.
So you have drafted this or something like that.
Not my
Power of attorney has
not
come
been
to an
drafted
end
by me, but
as soon as the it's a legal point. Power of attorney comes to an end as soon as the person.
yes, but
dies.
if he's not intimated the demise, he act on the basis of the power of attorney.
You have to
The banks will
you
not
have
know.
to inform the bank.
I have written to bank
Yes.
bank on this
Then-
point, my lord.
Then it will be a criminal flavor. It will come. If
Jewelry is mentioned in the income tax file. He's undervalued it and suppressed the value of it in the affidavit of assets so as to take advantage of this thing.
whether the will has mentioned everything about these jewelries or bank
The will,
accounts.
the will has not. Will is first of all, my allegation is that the will is forged. Is a forged will, forged and manufactured will, and it has given certain details, but it's not complete in all its details, my lord.
Okay.
The estate of the deceased has not been entirely dealt with. That's what.
Now,
and
now,
it's been
now,
given.
what would be the function of the
None-
administrator?
None of the one.
What would be the function? What?
My lord, the control of the estate is to be taken by the administrator of the estate. The shareholdings and the depositories also need to be taken control of, because there are a number of companies in which the deceased had controlling interest, and those companies
I shall ask the administrator to go and collect the shareholding certificates or everything.
yes, my lord, because the company's control is currently lying with the executor, and he's abusing.
You have to show first that these shareholdings are in their custody. Specification of shares and everything.
My lord, those
how can I allow?
Those details are there, my lord. Those details are there. I can bring it to your lordship's.
এখন তো it's all final. আবার কি bring it?
You have to file the details. Otherwise, how can I ask my officer to go and?
Your lordship, I will file a supplementary affidavit and give it.
Finally don't. Because Milad, this Milad.
I'm hearing him. Please.
আচ্ছা ঠিক আছে।
Yes. Please carry on.
My lord, if these details are available with us as to the deceased shares in various companies.
Details are available with us. Why you have not incorporated?
My lord, not happily drafted. This was not. This is a change brief. My lord,
he has nothing to say. Withdraw it.
My lord, I can give the supplementary affidavit. All the details. I'll bring it on record. I have no issue.
My lord, the first pertinent question that fallen from your lordship.
Pertinent questions.
Very much. That whether this includes in the will.
kindly comes to the will, the probate application is there.
Probate application.
Yes. That bank locker, shares.
Now, if they are succeeded to prove that the wills are forged, then
Right. That finally this court will decide, because it has already become testamentary suit. I am only on that. And kindly comes to the will.
Yes.
Well, at page 19 of the Millet PLA.
Yes.
Now, Millet kindly comes to gold and silver jewelries part, page 21. Third paragraph. I hereby devise and bequeath the gold and silver coin, jewelries and ornaments to my wife, the mother of Millet, the applicant, Srimati Bina Tibrewal. In her absence, the same will devolve in amongst my two sons in equal portion.
In her absence. Absence
she is
means-
alive.
In her absence means?
After her death.
This is also not happily word. In her absence, after her demise or something like that, or whatever. In her absence.
So we can't change it. That is there.
In her absence.
I bequeath all my movable and movable properties and money security not hereby or by codicil otherwise disposed of, to which I am entitled to at the time of my death, unto my executor, who shall have the power to alienate and transfer the whole or any part of such property if he considers that such alienation or transfer is necessary for the proper administration of the property, and shall distribute the same amongst my wife and two sons in equal portion. And such and such. Malad will kindly takes, Milad, at the top of that page only, Milad, the bank account. There are two bank accounts which have been mentioned by the deceased.
21.
21, first paragraph.
Yes.
Page 21, first paragraph.
Yes.
I devise and bequeath unto my wife such and such all my monies in savings and current accounts of several banks, his Axis, State Bank, HSBC and Allahabad. So, there is no whisper of Punjab National Bank account. But my landed friend is suggesting to injunction Punjab National, that is not made a part of the testamentary proceeding. I also devise and bequeath all my fixed deposit, mutual funds, shareholdings in various companies and various other investment here to my wife. However, in our absence, the monies in banks, the fixed deposit, mutual and shareholder and others shall equally devolve unto my two sons, Ingit and Tanay. My Ingit and Tanay. Two sons.
Who? Tanay.
Tanay.
He is from?
He is Khushi, the
yes.
sister. Well, this is the whole part. What has been bequeathed, and kindly, this is the ending part.
In respect of daughter, nothing has been.
Yes, daughter has been given.
Where?
Page 2.
Page 2. Page 2.
Paragraph 2. I hereby devise and bequeath my undivided 50% share and interest in my ancestral property, being such and such at Shuri, to my daughter. That is a joint property. To my daughter, Khushi Bhojnagarwala, with full rights and powers of disposal of my 50% undivided share and interest in the said property, fully marked and as scheduled.
Yes.
So, the estate has been equally distributed. The immovable property had gone to the daughter. And with regard to bank accounts, those are the specific bank accounts, which Axis Bank, State Bank, HSBC and Allahabad Bank. Now, PNB could not have been made a part, because why? PNB is a joint hold. The wife is a joint holder. So, it doesn't solely belongs to the testator. Anyway, it could not have been made a part of the will, because which does not become solely to the testator, that bequeathment cannot be there. Now, with regard to the shares, Malaysia, whatever he is saying, whatever is there in the will, the affidavit of assets has been filed corollary in the will, what has been given. The property which is not made a part of the testamentary or the will, may I put this question to myself, appropriately fallen from your lordship, is this a part of the will?
Answer. You answer. You have
not a part of the will.
Asked your question you to yourself.
Yes, not a part of the will. Not a part of the will.
Okay, then.
Number one.
Then they want to file a supplementary affidavit to satisfy my query that they have certain documents to show that those assets.
It's after affidavits. reply, opposition, everything done. Fighting out once dismissed for default.
Oh, I see. Next.
After long, it's filed in last year to last year.
Okay. Next.
Now, my lord, with regard to my lord, appointment of my lord administrator pendentility. Now, my lord kindly comes to my lord 247 under
There-
which
there is a in the affidavit of assets or will in the will the shareholding public Aditya Birla Capital
those are being given in my affidavit of assets.
they are given to all the sons or both the sons wife
in her absence, both the sons. Now, my lord kindly comes to me 247
47 of what?
Of the section that my lord administrator pendentility.
এই দেখি দাও ওইটা দাও ইন্ডিয়ান সাকসেশন অ্যাক্ট দাও ইন্ডিয়ান সাকসেশন অ্যাক্ট থাকবে 240 এই বইগুলো একদম হাতের কাছে রেখে দেবে 247 yes
Pending any suit touching the validity of the will of a deceased person or of obtaining or revoking any probate or any grant of letters of administration, the court may appoint an administrator of the estate of such deceased person who shall have all rights and powers of a general administrator other than the rights of distributing such estate, and every such administrator shall be subject to the immediate control of the court and shall act under its direction. Now, my lord, the law which has been streamlined now, my lord, I will rely on several high court judgments, my lord, that my lord 247 is one of the most stringent and strictest order that a court can pass. Now, my lord, the allegations which are being made perhaps not appropriate or my lord qualify to get a third party be appointed as an administrator pendently. Now, my lord, on that, my lord, very recent judgment of Delhi High Court have streamlined the issue.
similar
247 file is 2022 SCC online Delhi 4580.
247 Indian Succession Act. You are on behalf of propounder.
Yes. 2022 SCC online Delhi 4580.
Yes.
It kindly comes to page 23. At the top page numbers are written, page 23. Findings and analysis.
23.
Kindly comes to paragraph 35.
Yes.
35. It is the trite law that testator's wish regarding as to who will be the executor of his estate and carry out his will must typically be respected, and an executor named by the testator should not be removed from his office unless there is convincing proof that his continued appointment would be harmful to the estates of the deceased and frustrate the testator's will. The named executor cannot be removed for a few isolated minor mistakes. This concept must be considered when determining whether the petitioners have provided enough evidence to have the executor removed from his or her role. According to section 211, the executor of a deceased will serve as the deceased legal representatives for all purposes and becomes the owner of the deceased property as soon as the testator passes away. It is reasonably well established legal principle that the executor may exercise his authority and carry out the conditions of the will even if probate is not granted. In fact, one of the key differences between an executor and administrator is that the former may act even before the obtaining probate, while the latter cannot act until he has been awarded letters of administration. The interest of an executor in the estate of deceased vests in him immediately on the death of the testator. Therefore, courts will not readily remove an executor appointed in probate proceedings unless gross misconduct, gross mismanagement, abuse, or misuse of probate is demonstrated. There must be clear evidence that the executor's continued presence in debt is detrimental or detrimental to the property and would frustrate the will which he is charged by law and the records of the will to the administrator. Minor errors, erroneous assessment, or inadequate handling of matters are not sufficient to replace the testator's expression of confidence. Now, then section 47 has been quoted. Thereafter, along with section 301, there is a relevance also. 39. It is important to observe that these sections do not highlight any guidelines for removal of any private executor or administrator. While exercising power under section 301 of the Indian Succession Act, the court must ensure that no malicious or misconceived grounds are raised to throttle the intentions of the testator by way of an application to remove the testator. If the court is of the opinion that the executor has acted or is acting improperly qua the estate, or is acting in contravention to the intention of the testator, then it shall be justified in exercising its jurisdiction under section 301 of the Act in removing the executor and succeeding him by another. The main test which must guide the court in reaching this conclusion is that the best interest of the beneficiary, even want of honesty or want of proper capacity to exercise duties or want of reasonable fidelity could justify an order under this section directing removal of the executor. Now, my lord, kindly comes to paragraph 40. In view of the above said principles, I am unable to agree with the contentions raised by the learned senior counsel that a case has been made out for appointment of an administrator pendentility, more so as in the instant case no application has been moved under section 301 of the Act to remove the incumbent executor and provide for succession of another person to such an office. Learned senior counsel or respondent has submitted that it is not necessary to move an application under section 301 before moving an application under section 247 of the Act and has relied upon a judgment such and such to contend that an application under section 301 for removal of the executor can only be maintained by one who accepts the will, as otherwise it would tantamount to blowing hot and cold at the same time. Therefore, the respondent number 4 cannot be asked to bring forth an application under section 301. That's all. Now, the aforesaid judgment relied upon by the learned senior counsel as subject, the learned court has distinguished. Then 43. Accordingly, I am unable to accept the submission so made by the learned senior counsel, as if such a case, then section 301 will be rendered superfluous, which is not only against the settled rules of interpretation, but is also in the face of the intention of the legislature. The other issues are decided. Now, there is also a judgment of Madras High Court. এই যে যেটা জায়াজিরাম নাকি জিয়াজিরাম নাকি Let kindly see. আরেকটা কপি দিচ্ছি। এটা একটা কপি দিয়ে দিচ্ছি Let kindly see paragraph 3. Pending probate original petition, the petitioner has filed a petition in IA 115 of 2019 seeking orders for appointment of administrator pendentility till the disposal of the original petition to the administrator. The schedule mentioned properties and the learned trial judge, after inquiry, has passed the impugned order dismissing the said petition. The learned trial judge, by observing the genuineness of the will, can be decided only on inquiry in the main OP, so main probate, that the appointment of an administrator pendentility is one amongst the hardest remedies which cannot be granted merely on saying that the income from the property is being drained off, and the appointment of the administrator would infringe the legitimate right of the respondent number 1 and 2, has come to a decision that the petitioner is not entitled to get appointment of administrator pendentility and dismiss the petition. The learned counsel will review such and such. Considering the rival contentions of both the parties, this court is of the view that the decision of the learned trial judge in dismissing the application cannot be found fault with, and more particularly when the main OP is pending for trial. But at the same time, considering the nature of the petition pending for such and such, of the view the necessary direction are to be given to the trial court to dispose of the OP, similar the main petition, with this stipulated by this court, time to by this court. Now, in this case, my judges before documents are ready. I have served on them and filed in the department also. Number 2, this petition, apart from this petition, an application was filed for appointment of handwriting expert by my learned friend.
Today is not fixed.
Mukherjee. That got dismissed. That also got dismissed. Now, everyday applications are coming. On the other hand, written statements are filed, everything is final. On the other hand, the suit can be expedited. And if looks into order of 18th April of, it must be in my lord's record of Justice Mukherjee.
এই দেখো তো ওরা তো এখানে নেই।
এই 18 kindly comes to page 2, middle paragraph. Page 2, middle paragraph. In the aforesaid, when this application was moved for the first time, in the aforesaid facts and circumstances at this stage, the court is of the view that the said locker should be opened and inventorized to find out whether the jewelry such and such are lying at the said locker. I am also prima facie do not find sufficient materials to form opinion at this stage for removal of the executor appointment of an administrator pending. So
this prayer was made.
This prayer was made and refused.
Then again, they have come back.
Because they again come back before a lordship, and this order was never referred to a lordship.
Yes.
So, it has been refused. No appeal has been preferred from this order. Now, with regard to interim injunctions, with regard to injunctions, whether it can be passed or not, kindly considers in a PLA proceeding, kindly considers the averment. What she is claiming, ownership in a probate proceeding. This is a settled law, one of the first principles of law, that in a probate proceeding, ownership is not decided. Kindly comes to her application at page 6, Roman 3, that my lord, he read over to your lordship.
Yes.
Kindly takes the application page 6, Roman 3. I.
কোথায় গেল এটা এইখানে
GA4.
GA4.
I. Page 6, I.
Yes.
Kindly see the first line. The deponent is the owner of undivided 1/4 share in Hindu undivided family as per the latest amendment of the act, and upon the demise of this deceased, the share of the deponent stands at undivided 1/3 share, but the sole executor is trying to hide and suppress the details of the assets of the HUF. So she is claiming ownership in a probate proceeding. She is claiming an order over an asset which is not a part of the probate proceeding. And thirdly, when the main prayer has been rejected, that at this stage, the court had found that there is no question of removing the executor. That was not even disclosed to your lordship. Now, apropos the injunction that he said that injunction to be passed, kindly takes page 2, section 269 once.
In this petition, he has made such prayer. No?
Yes, 269.
Just a minute. What is the prayer?
The prayer at page 8, general citations.
Aspect page 8.
Yes. No. Master summons. No, sorry, I'm looking into the PLA. Kindly take the master summon.
The master summons thou.
Administrator pendentility to collect, preserve and accumulate various assets. In the alternative, fit person be appointed to as the administrator pendentility as a receiver of the goods, assets, jewelry and properties, and or then prayer C, an order of injunction do issue against the said plaintiff, restraining him from removing, transferring alienity. three milad A, B are with regard to milad administrative pendability, C is milad injunction.
Yes.
Now, milad whether injunction can be passed in a probate proceeding. That is the issue. Now, milad kindly takes page 260. Milad, I have shown A and B has already been refused. Administrative pendability has been taken care of the milad by Justice Mukherjee milad. No appeal has been preferred.
কোনটা দিয়েছো?
Master sir.
কি দিলে?
GF4
কি
এর
দিয়েছো তো? GF4 এর দাও।
এই তো।
Come back at 2. Come back at 2. ঠিক আছে।
Come back at
এ কোথায়?
My lord, in any, if a lordship is has to come back at 2, but lordship, there are certain judgments he cited and certain other
You will
things.
get opportunity.
My lord, we require some time, my lord. So kindly, let him come.
I will give you time. Please come back.
Don't be afraid.
কি হয়েছে এটা? ঠিক আছে। হবে আসছি আমি 2টোর সময়, হ্যাঁ ঠিক আছে। এইগুলো নিয়ে নাও।
Item number 13.
Now, my lord, with regard to the issue of, my lord, I have shown to your lordships that prayer A and B are with regard to, my lord, appointment of administrator pending delete. My lord, that issue has already been
Master, someone's. Yes.
now prayer out of, my lord, 3 prayers, my lord, the last prayer I am not taking, my lord, such further and other orders.
Why is your other side?
My lord, out of 3 prayers, my lord, 2 prayers are, my lord, with regard to, my lord, seeking with prayer appointment of administrator pending deleted. That has been already decided by Justice Mukherjee. That, my lord, at this stage it is not prima facie, there is no grounds. Now, my lord, the last option remains, my lord, last prayer remains prayer C of, my lord, of passing an order of injunction. Now, my lord, apropos to that, my lord, whether in a probate proceeding an order of injunction can be passed, my lord, kindly consider section 269 subsection 2 of the Indian Succession Act.
Two
269.
269.
Yes. When and how district judge to interfere for protection of property. Until probate is granted of the will of a deceased person or an administrator of the estate is constituted, the district judge within whose jurisdiction any, my lord, this falls within my lord jurisdiction, any jurisdiction or any part of the property of the deceased person is situated, is authorized and required to interfere for protection of such property at the instance of any person claiming to be interested therein, and in all other cases where the judge considers that the property incurs any risk of damage, loss or damage, and for that purpose, if he thinks fit to appoint an officer to take and keep possession of the property. Now, 2, this section shall not apply when the deceased is a Hindu, Mohammedan, Buddhist, Sikh, or Jaina, or any exempted person, nor shall it apply to any part of the property of an Indian Christian who has died intestate.
To whom it will apply then? To whom it will apply then?
Let 269 2 is very much clear.
Yes.
So it will, the deceased is a Hindu. Now, apropos, there are some judgments, which I should rely upon, because these points are regularly being agitated before many courts. Now, kindly comes to AIR 2007 Bombay, page 62. Kindly
AIR Bombay,
page 60, 2007 Bombay 62. That is Maharashtra Law Journal, but I am giving the citation which is easily available. Kindly comes to paragraph 11. No doubt. Starting with what? No doubt. Paragraph 11.
yes.
No doubt. Not only section 141, but the entire CPC is applicable to a testamentary suit. Therefore, the power of the court under order 39 would also be available to the court for making orders of temporary injunction. But for making an order of temporary injunction, under order 39, the property in relation to which the order is sought has to be subject matter of the suit. That I have shown to your lordships. the bank account upon which an order of injunction is being sought is not the subject matter of the suit. 4 bank accounts have been designated: Axis Bank, HSBC, 3 bank accounts: Axis Bank, HSBC, and State Bank of India, at page 21 of PLA, mentioned in the will. Now, similarly, is the case with the provision of Order 40 in relation to appointment of receiver. An order of temporary injunction or an order appointing the receiver can be made by the court only in relation to the property which is the subject matter of the suit. A civil court can also make interim order in relation to property which is not the subject matter of the suit, but interim order in relation to such property is necessary to be made to secure the execution of the decree that the court may pass in the suit. However, in a testamentary suit, property left by the deceased is not the subject matter of testamentary suit. The nature of decree that the testamentary court passes is such that to secure its execution, it is not necessary for the court to make any order in relation to any property. Then Miller Division Bench of Patna High Court has been referred to, that has been Miller set out. When it kindly comes to paragraph 12, it is thus clear that in a petition for probate of a will or a petition for grant of letters of administration, the sole question that arises for consideration is whether or not the will is genuine or not. The property left behind the deceased is not the subject matter of the decision of the probate court. These observations were made by Division Bench of Patna High Court while considering the question whether a caveat filed by a person whose disputes title of the testator to the property is maintainable or not, and the Division Bench has held that a caveat filed by such a person is not maintainable. The Supreme Court referred to the decision of Patna High Court. Miller, with regard to AIR 2004, Supreme Court has referred to the Patna High Court judgment that has been set out there. Now, let kindly turn the page. Paragraph 13. It is thus clear that the Supreme Court has held that the proposition of law which is laid down by the Division Bench of Patna High Court in this judgment of Kashinath Singh case is undisputable. The Supreme Court has also observed that the testamentary court has no jurisdiction to go into the question of title of the deceased to the property mentioned in the will or property which may be or may not be left behind by the deceased is not the subject matter of testamentary suit. And therefore, in my opinion, in exercise of its power under the Civil Procedure Code, the court would not be entitled to make any interim order in relation to the protection of the property unless an order is required to be made by the court in peculiar circumstances, part 7 of the Act. In a testamentary jurisdiction, the court is only concerned with the with the genuineness of the will. Neither the ownership is decided nor any title is decided, and neither the subject matter of the deceased is the subject matter of the suit. Only the will and solely the will is the subject matter, and that can only be decided after this court has gone into the merits of the probate proceeding, not at the interim stage. Now, next is AIR 2007 Bombay, page 136.
AIR
2011 Bombay 136. বলছি পাটনাটা ওর ভেতরে লেখা আছে, এটা বলেছে সাইটেশন, আমি এটা ছিল। Kindly comes to Millard.
It does not tell you its
Millard, but it will tell you. Millard, I've checked.
50th. It is
Paragraph 14.
Paragraph 14.
Give me a moment. Yes, yes. And paragraph 14. Treatise Millard with the reported judgment of Bombay High Court. Millard starts. the division bench of this court, while interpreting the provisions of section 295, which provides, has my lord found paragraph 40, which provides that in contentious cases, the proceeding before the district judge shall take as nearly as may be the form of regular suit, according to the provisions of CPC. Then thereafter it has been quoted. Now it has been emphasized on behalf of the appellant that the words all matters connected therewith in section 266 have a broad connotation, and that section 268 emphasizes that the proceeding before district judge in relation to the grant of probate and letters of administration will be regulated so far as the circumstances of the case permitted by the Code of Civil Procedure 1908. It is contended that the power to grant interim order in necessary adjunct of the power of the civil is the power of the civil code. The ambit of the words all matters connected therewith has to be construed in relation to grant of probate and letters of administration. Such a proceeding does not concern itself with title or even the existence of the property, but only determines whether the will was executed by the testator of his own free will. That being the ambit of proceeding, the words connected therewith cannot transform the probate proceeding into one in which issues aligned to the grant of the probate are to be decided. That would be impermissible. The contents of the broad general language in section 266 and 268 must be read in context of the specific provision which are made in section 269 that Miller I read over to your lordships. The legislature in subsection 1 of section 269 made a specific provision to the effect that until probate of the will of a deceased is granted or an administrator of estate is constituted, district judge is authorized and required to interfere for the protection of such property at the instance of any person claiming to be interested therein. Number 2, in all other cases where the judge considers that the property incurs any risk of loss or damage to do so. For the purpose, the district judge is empowered to appoint an officer to take and keep possession of the property. While recognizing and conferring such power expressly on the district judge, the legislature nonetheless mandated in subsection 2 that this section shall not apply when the deceased is a Hindu, that part, such and such. When section 268 emphasizes that save as hereinafter otherwise provided, the proceeding before the district judge shall be regulated by the CPC so far as the circumstance of the case permit. It is not open to the district judge to exercise a power contrary to the legislative intent and mandate of section 269 until probate of the will is granted of a deceased person or an administrator is constituted. The statute has recognized the power of the district judge for the protection of the property at the behest of a person claiming to be interested, and in all other cases where the judge considers that the property incurs a risk of loss or damage. But just as this power is specifically conferred upon the district judge, subsection 2 precludes exercise of the power when the deceased belongs to one of the categories specified in subsection 2. If the provision of section 266 and 268 were broad enough to bring within the purview powers of the nature specified in subsection 1 of section 269, there was no necessity to incorporate a provision in the nature of subsection 1 of section 269. As a rule of interpretation, the court will not ascribe or attribute the use of a surplusage to the legislature. But even if an alternate construction is possible, one that recognizes subsection 1 of section 269, one makes implicit a power which is exercisable under section 266 and 268. The effect of subsection 2 is to preclude the exercise of that power in the case of one of the accepted categories. It would not be permissible in the face of the specific provision of subsection 2 of section 269 to read into the provisions of section 266 and 268 a general power to grant interlocutory relief even prior to the grant of probate in respect of the property which is alleged from part of the estate of the deceased. This construction is fortified by the principle that testamentary court in proceedings for probate is only concerned with the question as to whether the will of a deceased is genuine and that it has been made voluntarily. The probate court is not concerned with the question relating to the property itself. Though an assiduous attempt was made on behalf of the appellant to rely upon the provisions of this act, to which a reference has been made earlier, this court in this case is essentially concerned with the power of the testamentary court when it exercises its jurisdiction in a petition for grant of probate. In view of the express provision which is contained in section 269 subsection 2, there can be no recourse to exercise the inherent power of the civil court. There can such and such, this however would be, it would not preclude the recourse to a civil suit. That is all. So injunction.
So for injunction, he can move civil court.
But not in the probate proceeding. Because probate proceeding is a leak together with regard to other or normal suits.
Anything else?
Only some factual things. Initially, I should be candid before your lordship. Justice Mukherjee, when my lord was taking up these matters, was of the view that we should take instructions whether we are agreeable for inventorizing the bank account. By a written communication, bank locker. By a written communication from my client through my advocate on record, he directed us to give a written communication. Whether he was of the view that whether I give consent, my clients give consent or not. By written communication, we have informed the learned judge at that point of time that my client is not willing to give any consent. That was also consigned to records. That was there. I don't know whether the entire record has come or not. That was there. That my advocate on records letterhead was there. Giving the mail which has been forwarded by my client.
But that is not relevant so far as this application is concerned.
Yes. But it was fallen from your lordship that my lord
fallen from
no, not my lord, by Justice Mukherjee or Indam Mukherjee. That we should, if we can take a instruction by consent, whether we are agreeable to get that bank locker inventory or not. My client did not agree, to be very frank before your lordship. And by the written communication, that is there on record. The orders are also there. Recording the written communication. So, these are my submissions. If kindly takes the affidavit of assets, what had fallen from my learned friend, that shares with regard to proper bank account, companies of Malaysia on it. Affidavit of assets. It's my duty to show the affidavit of assets also. Yes. And this is the affidavit of assets filed by the executor. That kindly comes to paragraph 3, page 2. Kindly sees all the shares of Malaysian company.
Yes.
We have disclosed. Kindly see paragraph 3. I am not reading to kindly see. Then kindly comes to all the Malaysian companies. Then kindly take page 3, bottom, schedule A. Valuation of the movable and immovable properties of the deceased. And kindly takes page 4. Whatever the deceased has bequeathed has been encapsulated in the affidavit of assets. And this goes on. And kindly sees the bank accounts. Axis Bank, State Bank, Allahabad Bank, and HSBC are all being given, which in bracket page 21 of the probate application has seen. Those are mentioned by the deceased. Now the immovable properties. Shiuri property, then thereafter Salt Lake property, then movable properties, shares. Kindly takes page 6. Movable property with regard to shares of the companies, Indian companies, mutual fund, share or dematerialized shareholding in Millet Bank or Allahabad Bank, share scripts, goes on to page 9, and Millet along with the valuation. And whether Millet the will is forged or not, but perhaps that Millet cannot be decided at this stage. And Millet, they have already taken a try to get appointment of an Millet handwriting expert under the Millet that has been dismissed by my Lord Justice Mukherjee, challenging that the signature is not the real one, it's forged.
So that was not allowed.
That was not allowed.
No appeal.
My lord, that was the his lordship held that this is premature at this stage. This will be determined at trial. It has never been said that this is a completely settled question. He is portraying it as such for his own purpose, but that is not the correct picture.
No, the order which is there. I cannot modify the order. That was GA5, passed in GA5.
Order did it?
$1 million.
25th July.
8 on the no, এটা পরে 8th August
25th July.
This is July. 25th July.
When the will was executed, when the will was executed,
will. Moment. 3rd day of November 2019.
What is the date of death of the execute president?
27th of March 2020.
Within few months. Within a few months. 29 and 20.
November till March.
5 months.
When I'll give that order, Millard, when Millard that Apple GA5 was dismissed. আছে
GA5. Order পাঠাবে দেখাও
22nd August 2023.
No, এটা না
এই 3 পাতার অর্ডার আচ্ছা 2 পাতার অর্ডার kindly seize Millard
কপি থেকে বাদ
আছে দিয়ে দেবো
এক মিনিট order.
Only one copy. Kindly see Millard page 2, second paragraph.
জিএটা প্রিমিয়ারি গেছে জিএর সাথে নেমে গেছে
একটা তো অর্ডার ফাইল হওয়া দরকার
আলাদা আলাদা অ্যাপ্লিকেশন করেছে
আলাদা হয়ে যায়
রেখে দিই
ওকে
এটা থাক অর্ডারে kept on record মানে these applications are only keeping the matter adjourned
এই ডেটটা দেখো তো কবেকার ডেট ওটা
22nd August 2023
yes
so Miller already Miller 2 attempts have been made one is pending Miller this application also got dismissed for default subsequently got restored then it can be full Miller this suit is not proceeding at all despite judges if already been filed. And what is happening is, as the GAs are pending, the department is also tied bound cannot put the suit for final hearing. These are my submissions with regard to So this application should be dismissed, and the main title suit, testamentary suit, can be heard and disposed of because it's already ready for hearing.
Yes.
The number of things he said, I cannot possibly I won't go into all of it right now, but I'd just like to bring something to your lordship's attention. Lordship, the will deals with HUF property. It specifically mentions that the deceased share of the HUF property shall devolve on by way of the will vest in his wife, the deceased wife, and 2 sons. In such a question, his entire point that this is not a question, this is not going into questions of ownership of title. I am not going into questions of ownership of title. However, if the will deals with HUF, share in an HUF, the HUF's properties, assets should be brought into the affidavit of assets. They've deliberately suppressed such. They've deliberately suppressed such so that they can take advantage of its non-dealing, non-dealt with, and dispose of such properties and assets. Moreover, lordship, another thing with regard to the affidavit of assets, my lord, lordship will kindly see, starts off, kindly see Schedule A. Gold coins, amount 1320.
Page number?
Page 4 of their affidavit of assets.
Page 4.
Schedule A, valuation of movable and immovable properties.
Yes. What one?
Gold coins value 1320. Is one gold coin available at 1320? I highly doubt.
Coins. And then thereafter jewelry ornaments.
Jewelry ornament, silver coin and utensil 2997. Whether 2 silver coins can be available at 2997, I highly doubt. This is the conduct of the executor, my lord. This is their affidavit of assets filed in court. One lordship expect to believe that gold coins multiple, where valuation is 1320. This is the conduct. Lordship, the entire point of this of the executor is trying to take away every value of the estate and leave their poor sister with nothing, take all the benefit and leave nothing for the thing. To show this entire concocted will has been conjured up in such a manner in total to show that something has been left for the sister. Ancestral property 50% share has been left for the sister. Everything else has been given to the executor and his brother. Everything else, every other benefit.
So it is better to proceed with the
my lord,
main proceeding.
My lord, if your lordship will give a time bound, we will agree right now. But lordship, the entire point is they are right now saying that the final suit is ready for hearing. Let it have it heard. Moment the final suit actually comes up for hearing, they will themselves delay on the matter.
I think to prove that onus lies upon them.
By that time, my lord, the entire estate will be gone. Entire estate will be gone.
If he agreeable, we can expedite the suit. We'll frame a timeline. No difficulty. I'm ready.
Okay. I can do.
Yes, we'll frame a timeline. It will be hard before a lordship only.
My lord,
what's the difficulty?
But my lord, the entire point is,
whether you want to file a supplementary affidavit.
Yes, my lord. I wish to bring certain parties to record.
Indicating what?
Certain shares, certain companies, certain.
But why you have not given? Why you have not mentioned?
Not happily drafted. I am not the advocate who has drafted this. I came into the matter later on, my lord.
Whatever it may be, but you
my lord, can you give a week's time?
No, my lord.
A week
you can withdraw. You can withdraw. We shall proceed with the
proceed with the suit. I undertake.
Just a minute, Mr. Acharya, Gupta. Then that's Gupta.
My lord gives. Heaven will not fall in 1 week. Heaven will not fall in 1 week, my lord. Kindly give me 1 week's time. I will give what.
No,
what is this?
That cannot be done. If you withdraw, then you can come back with fresh. That can be done. But right now, after hearing everything,
my lord, at least
so this was my
allow
question.
allow me to deal with their judgments. I'll come back on that. Can you give the short date? I will deal with their judgment and I'll come back on this.
When you will come back?
Give a couple of days, man.
Yes.
Next week.
Next week.
Next week, Monday.
Monday. Very good. The learned counsel for the petitioner in respect of
GA4.
GA4 of 2023 or 24?
23.
23 has concluded his argument.
No, my lord, I am the respondent there. His application.
It's
Yes.
my application, man.
He has concluded his
He's
argument.
confident.
Has concluded his opening submission, and the learned counsel for the respondent has also concluded his submission. However, the learned counsel for the petitioner seeks time for replying on points of law. This is the matter on Monday.
And clarification of certain facts, man. That's all. Certain factual aspects I will clarify.
Then he will be given some opportunity to rebut.
No problem.
And he will have no problem. At the long it goes on, he will have no problem. Kindly see the Millard orders passed, adjournment taken as like galore.
Okay. No adjournment will be granted.
They are right now enjoying the benefit of the estate. I don't know why my learning.
I am inviting you to enjoy. Come and enjoy with me.
No. So that's the thing. You
Okay.
come to
You are not
you are not coming to a
I'm
settlement.
inviting you to come over on Monday.
Yes.
Okay. This is my invitation to you, to all of you. Next.
Item number 14.
May it please your lordship, my lord. My lord, your lordship has been pleased to hear this matter on a previous occasion.
Yes.
Lord, this is a will. This is with regard to a will, my lord, of a single lady, my lord, who at the time of her death did not have any blood relation surviving, as a result of which, my lord, she had bequeathed all her properties to a person whom she was looking upon as her own son. My lord, I had, my lord, placed the pleadings on the last occasion, my lord. Your lordship was pleased to direct me, my lord, to place the affidavit in support of the caveat, inasmuch as, my lord, no one is representing them. Your lordship recalls, my lord, they had been representing. The witness action took place in their presence. They have cross-examined the witnesses. Thereafter, my lord, at the last stage, when the argument was to commence, my lord, no one represented on behalf of the caveatrix, in spite of repeated opportunities given to them. My lord, the last order was also handed over to your lordship, if your lordship recalls. My lord, the order of Justice Mozumdar, na? Yeah, Justice Mozumdar.
Order date.
That order is dated. Yes. 8th of February 2024.
Yes.
So, my lord, this is the position. And
I have also asked you to prepare a list of dates.
yes, I've got it right. I've got it.
Hmm.
May I hand over, my lord, a copy? Most of the dates are coming from the affidavit in support of the caveat. My lord, the last occasion, my lord, I was placing the affidavit in support of the caveat. My lord, it was your lordship's pleasure that I place, inasmuch as they are not representing now. So their case is also being brought to your lordship's notice, my lord.
Yes.
My lord, I had finished placing up to paragraph 14 of the affidavit in support of the caveat. My lord, their case in short was that the person whom the property has been bequeathed, the propounder, was a servant, and that he had never looked after, and this caveatrix is the wife of the predeceased brother of the testatrix. And testatrix case is that the predeceased brother was never married and he died prior to the death of the deceased, and that these people were never part of the family. And my lord, in support of their case that I brought to your lordship's notice, there has not been any wedding certificate produced. She is saying that she had 3 children through this wedlock, no birth certificate, as has fallen from your lordship.
Full certificate was produced.
No, my lord, with respect, one child out of the 2 sons, 1 son predeceased. So they have produced a death certificate where they have mentioned that the father is the name of the predeceased brother. But at that point of time, the brother was also not alive. So, my lord, my humble submission would be they have done it on their own. They could have put any name whatsoever. There is no other document to show, my lord, the wedding certificate or wedding photographs or photographs of the family being together. No evidence whatsoever. No evidence whatsoever. One document they have disclosed is the probate order. That also, my lord, I have shown it to your lordship. If your lordship kindly comes to page 32, running page 32 of the affidavit in support of the caveat, which your lordship is right now going through. Yes, my lord.
Yes.
My lord, last line, I had, my lord, pointed this out to your lordship on the last occasion. It has been stated that the testator had no other near relations save and except his nephews, sons, and niece Apurba Devi. She died on 16th of February 1978. Well, this is the grant of letters of administration which was obtained by the caveatrix on behalf of her alleged deceased husband. And there she is mentioning that the deceased died. Apurba Devi is the, my lord, the deceased here. Apurba Devi died on 16th February 1978 when she was very much present. She was very much present, my lord. She died sometimes, my lord, sometimes in Apurba Devi died. She died much later. She died, my lord, in at that point of time, she was very much alive. And my lord, this order was passed ex parte. She died on 1st of February 2006. We've got the death certificate. And the caveatrix, falsely, my lord, represented as if she died in 1978. And this order, my lord, was passed ex parte. That your lordship will get to know, my lord, from page 25. Ex parte is, no, page 23. Page 23. Page 23 of the affidavit in support of the caveat, my lord. Your lordship, see the ordering portion. Ordered that the case is allowed ex parte and the probate is granted to the applicant along with a copy of the will annexed, filing this, and this. So, my lord, she's had a clear field. She put in whatever date she liked. The Honorable Court felt that she was the only heiress, and the order was allowed ex parte, which subsequently was set aside. When these facts were brought to the notice,
when it was set aside?
Yes, my lord, that I'll be very candid with your lordship, my lord. That order we do not have because this property was subsequently sold off by the deceased. Inasmuch as the property was that of the deceased was having all the papers. Deceased sold off that property. And the buyer, the purchaser, after having got to know about this, yes, she during a lifetime sold the property, which the testatrix was claiming to be hers.
So this order was vacated or revoked?
Yes, this order was vacated by a third party, the purchaser. The purchaser subsequently, after having come to know of this order, there was an encumbrance on the property that he had bought. So he got it vacated. That order, my lord, we don't have it in hand. but it is for sure that it got vacated, and we have also got it deposed through the witnesses that the order got subsequently vacated. Well, I should. Yes, my lord. And well, there are many other documents, my lord, from which I'll show that the case made out by the caveatrix is not a genuine case. That, my lord, there are many other documents. Now, my lord, may I just, as I was just taking your lordship through the pleadings, may I just continue with that, my lord, or may I come to the will?
Yes, you can.
Your lordship will kindly come to paragraph 15 of the affidavit in support of the caveat.
Yes.
Paragraph 15. By an order dated 10th September 2008, the Honorable Justice such and such, while disposing of the aforesaid application, and been inter alia pleased to grant leave to me as also to my son and daughter to file caveat. A copy of the aforesaid order dated 10th September 2008 is annexed here and marked D. That is at page 39. Your Lordship recalls, my Lord, I had placed before your Lordship that they had not got the application. They got it through someone else who had also filed a caveat. Yes, my Lord, I'm deeply obliged. Gopal Ghosh's caveat was subsequently revoked. So, my Lord, now this is the second attempt. This is an application by persons claiming to be the widow and children of a predeceased brother of the alleged testatrix, claiming to have an interest in the estate of the alleged testatrix. The alleged executor says that the predeceased brother of the alleged testatrix did not marry, and there is no question of his having left behind any widow or children. The alleged executor submits that the present application is not maintainable as no caveat has been sought to be filed, but the applicants wish to straightaway file an affidavit to oppose the grant. GA number 2998 of 2008 is disposed of by permitting the appellants Maya Chatterjee, Siddhartha Chatterjee and Joyashree Banerjee to lodge caveats in support of the alleged will of Dr. Apurna Chatterjee, which is the subject matter of PLA such and such, within a period of 1 week from date. Any affidavit in support of the caveat must be filed within a period of fortnight from date, failing which the relevant caveat will stand discharged. So, my lord, this was the liberty that was given to the testatrix, to the caveatrix to file the affidavit in support, pursuant to which this affidavit has been filed. Now, my lord, paragraph 16. Pursuant to such leave granted by this Honorable Court on the 10th of September 2008, I have duly filed caveat through my advocate Rabindranath Bhattacharya on 16th September 2008. Since thereafter, my advocate had written a letter addressed to the advocate on record of Ram Iqbal Dubey, that is the propounder, seeking a copy of an application for obtaining letters of administration. Despite receipt of such letter, the petitioner's advocate had refused to supply any copy of petition. In the meantime, on or about 20th September 2008, my advocate had obtained a copy of the aforesaid application for letters of administration, along with affidavits of asset affirmed by Ram Iqbal Dubey on 6th October 2007. Advocate for Gopal Chandra Ghosh, a caveator in the proceedings, from the advocate, Mr. Gopal Chandra Ghosh. Mr. Gopal Chandra Ghosh has informed my advocate that the copy of the petition supplied is a true copy of the petition for grant of letters of administration as received by him from the Registrar Insolvency High Court. So, my lord, subsequently this caveat got discharged of Gopal Chandra Ghosh, which I have already placed before my lord. Then, my lord, paragraph 17. From the copy of the will annexed to the said application, it appears that a deceased has allegedly made and published the said will and testament on 10th November 2005. It is interesting to note that the deceased has purportedly indicated in a last will that my husband had died intestate and unmarried. Such statements are utterly false. The deceased under no circumstances could have made such a false statement in a will. I submit that the aforesaid clearly goes to demonstrate that the will has been procured by the alleged executor by fraudulent means. The said will allegedly published on 10th November 2005 is also not a genuine document. That is her claim. Then 18. In this connection, I say that I had been legally married to Asharam Chatterjee. Asharam Chatterjee is the predeceased brother. And out of the said wedlock, Siddhartha, Indranil, and Joyashree were born. I had, however, lost Indranil at his early age. So his Indranil's death certificate is the one where the mention of Asharam was there as the father. 19. I have further been able to ascertain from a perusal of the will, as aforesaid, that the will contains diverse incorrect allegations. I say that the will which is in aid to have been alleged, made and published by the said deceased, was allegedly executed when the deceased was 76 years of age. Unfortunately, the deceased at the age of 76 did not have any sense of understanding by reasons of a depression and loneliness. Further, the date on which the will was allegedly executed by the deceased was on her deathbed, and she was not in a position to make any judgment and further incapable of understanding the consequence of her actions. May I pause here for a moment, my lord? Now, the allegations of the caveatrix is that the deceased had suffered from depression and loneliness. My lord, on one hand, it is a specific case of the caveatrix that they had all along been associated with the deceased, and they looked after the deceased, and the deceased was a resident of Varanasi, and she is admittedly a resident of Bengal, sometimes in Calcutta, sometimes in Bardhaman. I put a question to myself: had her case been true, that she and her children had always been in contact with the deceased, the question of her dying out of depression and loneliness could never have arisen. So, from her own statement, my lord, this is contrary to the case that she is making. I will, my lord, elaborate on this. I'm just, my lord, highlighting the points that how improbable this case can be. Further, my lord, she is saying that the deceased was on a deathbed. Yes, my lord.
So you have to prove that she was in sound disposition of mind at the relevant point of time, because it is alleged that he signed the document on her deathbed.
Yes.
So,
My lord, for that, their deposition, one of the witnesses is a doctor. Doctor was a next door neighbor of the deceased. The doctor has all throughout looked after the witness from a very early age till the stage of her death. Her evidence is there. His evidence has been that when she died? She died in 2006, 1st of February.
When the execution was done?
Yes. 10th of November 2005.
She died
in February 2006. Yeah, this was a query of your lordship on the last occasion as well. But my lord, it would be my endeavor to show your lordship.
She was in sound
yes.
position.
She was a person, my lord, as I had brought your lordship's notice on the last occasion. She is a descendant of
lady.
A professor. She is a professor. She has published many books, and till her last, she was engaged in all this research work, and her publications have also come out. So from this, my lord, it can be evident of the fact that she was mentally very agile, and that she used to converse with regard to many subjects and topics with people of very educationally high level. All this will and intellect. All this will come out from the evidence, my lord, and nothing has been controverted. Nothing has been controverted. So, my lord, that onus is on me to satisfy my yes, my lord. That I know. That hurdle I have to cross. That, especially when they're not there. Yes. My lord, then that is the case, that incapable and deathbed. So that I have to, my lord, satisfy your lordship. Then, my lord, paragraph 20. I further submit that the aforesaid would corroborate from the recordings made in the will itself, allegedly made and published by the deceased, which inter alia records that the deceased had allegedly succeeded to diverse movable and immovable properties belonging to late Chaitanya Chatterjee, late Durgarani Chatterjee, and late Asharam Chatterjee. Chaitanya Chatterjee was the father-in-law of the caveatrix, father of the deceased, alleged father-in-law that she is claiming, and late Durgarani Chatterjee was the mother of the deceased, and Asharam Chatterjee, the predeceased brother of the deceased. Then 21. I further say that the petitioner, that is Ram Iqbal Dubey, in whose favor the will has been allegedly executed, cannot claim any right and interest over and in respect of the properties which the deceased had never inherited. My lord, this is something, my lord, she is claiming a right better than that of the deceased. automatically the caveat should get discharged. Right, the deceased had never inherited. So she is saying that all the properties which are there in the will, mentioned in the will, are not that of the deceased. I further submit that the petitioner had never taken care of Dr. Miss Apurba Chatterjee, nor there was any reason for Dr. Apurba Chatterjee to make and publish any will, making the petitioner as a beneficiary thereof. There, my lord, my responsibility will fall to show as to how, my lord, a doubt will rise in anyone's mind as to an outsider is being bequeathed with all the properties. What was the relationship with the outsider and that of the testatrix, my lord? That would be one question. How she had looked upon, since when they were associated, and whether there was anyone else apart from this person on whom this property could have gone. So, my lord, these in the ordinary course would be the questions. And my lord, I have to satisfy your lordship with regard to all this. And my lord, it is not that the propounder himself is claiming this. Whether the case has been made out by people, those who had known the as well as the propounder, who are established people of the society. One is a civil engineer, the other is a doctor. Doctor associated with Ramakrishna Mission and many other charitable, my lord, organizations, my lord, that would have some substance. It's not that any ordinary person is giving this evidence. And as I had told, my lord, that the deceased was a very intellectually enriched lady. My lord, she also used to like the company of people having enriched intellect. So she had sought to give these people, brought these two people as witnesses, one a doctor and the other civil engineer. So according to them also, they had, and there are photographs to show that the propounder is doing the shraddh, propounder has gone to the burning heart, because no one else was there. He used to look upon her as his own mother, and he performed all these rites. They're all there. And the caveatrix and her family is nowhere to be seen. I put a question to myself, had they been close relatives, they would have come during the death, at least if not during the day of the expiry because they stay outside, at least during the shraddh. Nowhere to be seen. There's not a photograph, no evidence, nothing whatsoever.
It is his obligation to inform them the death of the testatrix.
My lord, with respect, whom would he inform? There is no one.
Cannot claim that they do not appear.
My lord, at the same time, they are saying that they had been constantly in touch. Your lordship will also appreciate that. Their case is, yes, everything has to be considered. Their case is that the question of this person being given the property cannot and does not arise. Inasmuch as we are the close relations, we has always been in connection with her. We had been communicating with her. We had been coming and going. If that is so, the question then remains, my lord, why would she die out of depression and loneliness? And why would these family members, those who had been during the lifetime so close, would not be seen at all, either during the shraddh or during the last rites, or ever at all with this deceased? On any function, on any occasion, nothing at all. A family photo, something, a closeness, that is how, my lord, we project our closeness with someone. Nothing at all. So these also are the things that has to be weighed, my lord, with respect. My lord, then paragraph 22. The list of properties have not also been annexed to the affidavit of assets, which itself goes to demonstrate the illegalities committed by Ram Iqbal Dubey. I have further come to learn that Ram Iqbal Dubey had earlier filed a probate proceedings before the district judge at Varanasi, being probate miscellaneous such and such for getting this very will and testament allegedly made and published by the deceased probated. The said application had subsequently been withdrawn on 5th of October 2007 upon payment of cost of ₹500. No leave has been obtained by the said Ram Iqbal Dubey to file the instant proceedings for obtaining letters of administration when the earlier application was withdrawn. Suppressing all such facts, the instant application has been filed by the petitioner before this Honorable Court. I call upon the petitioner to produce a copy of the order which permitted withdrawal of proceedings before Varanasi Court. To this, my lord, my humble submission would be, I'll paste the provisions as to whether this Honorable Court has jurisdiction or not, inasmuch as the assets are scattered all over Bengal. Some are here in Calcutta, some are in Hooghly, some are in Bankura district. My lord, if I'm withdrawing a proceeding which has been filed wrongfully and I file it before the proper court, my lord, with respect, I don't need any prior leave. And I'll satisfy your lordship that this is the proper court which has the jurisdiction to entertain this application. That I will do in the course of my argument after I finish placing the facts. Paragraph 23. I have since, on further inquiry, come to learn that in the proceedings being probate number such and such filed in the court of learned district judge at Varanasi, diverse properties were included therein which did not at all form subject matter of the estate of late Apurba Chatterjee. As such, there are other suspicious circumstances surrounding the will. Then paragraph 24. I further say that the deceased has no mental and physical capacity at the age of 76 to execute the will allegedly made and published by her on 10th November 2005. The said Ram Iqbal Dubey is neither a blood relation nor was in close contact with the deceased except for a brief period prior to her death when he worked as a servant. And at that relevant point of time, I have reasons to believe that the said Ram Iqbal Dubey had got the aforesaid will prepared and had got the same registered through the imposter. Well, this Ram Iqbal Dubey is a person who has a master's degree to his credit. He's a businessman coming from a reputed family, having.
So he was not a servant.
Not at all.
No.
He was a student of my lord Benares Hindu University, where this lady was a professor. His cousin was also a student. That is how first he got introduced. All this will come out from the evidence. And my lord, as a young student, my lord, somehow she took a liking and he used to do the errands, having seen that she was a single lady, and he used to help her in, my lord, getting books xeroxed, in accompanying her to the publishers where her books got published. And ultimately, the association was such that he started staying with her. And she also started depending on him. And the son and mother relationship grew up. And this was also known to the family of the propounder. The family of the propounder means the uncle was the first person who got to know about, who was associated with this lady. And the families also knew each other. And that is how the relationship grew up. And she started depending on him so much so that she had also in the will, I'll place the will thereafter, said that all my last rites will be done by him, inasmuch as he looked after me and there is no one who has been beside me since all these years. Not a mention of the brother, and that she mentioned about the brother who was predeceased. No mention of the family at all, alleged family. But they are trying to pose him or project him as a servant. 25. However, my lord, there is no impediment to give one's property to a servant as well, if at all. 25. I further say that the petitioner taking advantage of the aforesaid has not issued any citation. It was only that the petitioner, having come to learn with regard to the institution of the proceedings before this honorable court, had moved an application being such and such, wherein an order dated 10 September 2008 was passed. 26. Without prejudice to the aforesaid, but fully relying thereon, I now proceed to deal with the allegations contained in the said application. 27. With reference to the allegations contained in paragraph 1 of the said application, I deny that Apurba Chatterjee, alias Dr. Apurba Chatterjee, had died testate on 1st February 2006 as alleged or at all. Because she's already made out a case that she died in 78. Well, the death certificate is there, which will show that she passed away on 1st February 2006. I deny that during the lifetime of the deceased had executed a last will or testament or had got the same registered in the office of the sub-registrar Varanasi as alleged or at all. I say that the said will is a forged document. The said document has been registered by an imposter. Under no circumstances the deceased could have executed such a will, indicating diverse false statements. I deny that Ram Iqbal Dubey is a universal legatee of the assets of the deceased as alleged or at all. 28. With reference to the allegations contained in paragraphs 2 and 3 of the said application, I deny that at the time of death, the deceased had left any movable and immovable properties in the district of Bankura or Hooghly in the state of West Bengal as alleged or at all. It is denied that the last will or testament was executed by Dr. Aparna Chattopadhyay alias Dr. Aparna Chatterjee as alleged or at all. I say the affidavits affirmed by Anand Kumar Tiwari and Bhupendra Vikram Singh are not trustworthy. These are the two attesting witnesses. No reliance ought to be placed on the same. There has been no proper execution of the will by the deceased. 29. With reference to the allegations contained in paragraphs 4 to 6 of the said application, it is denied that the deceased had executed or published her last will testament on 10th November 2005 as alleged or at all, or the value of the estate of the deceased is about rupees 13 lakhs as alleged or at all, or the value of the estate of the deceased is about rupees 13 lakhs, again the same. I say that since the petitioner has been taking a chance, the petitioner has chosen not to put in the court fees. Subsequently, my lord, it has been paid. Oh, no, my lord, we had paid that time itself. I do not know as to why she has made this allegation. It has been paid there. 30. With reference to the allegations contained in paragraph 7 of the said application, I deny that the petitioner has withdrawn the application merely because most of the assets of the deceased are lying in the state of West Bengal as alleged or at all. In any event, I say that at the time when the petitioner has withdrawn the application from the court of Varanasi, no leave has been obtained by the petitioner to institute proceedings afresh. Consequentially, the instant proceeding cannot be proceeded with. 31. With reference to the allegations contained in paragraphs 8 to 10 of the said application, I say that since the deceased had not executed any will, the question of intimation being received by the petitioner as regards grant of probate by any will of the deceased could not have arisen. I further say that I or my son or daughter were not aware with regard to the purported execution of the last will allegedly made and published by the deceased. Consequently, we have not filed any caveat. So, my lord, she kept on denying the allegations. Okay. If your lordship wishes, my lord, I'll continue with it. There are 2 more pages. When I've done so much, I'll just do 2 more. 32. With reference to the allegations contained in paragraphs 11 to 12 of the said application, it is denied that the petitioner is an universal or residuary legatee or is entitled to whole of the estate of the deceased, or there is no debt left by the deceased as alleged or at all. I deny that the petitioner has any interest in the estate of the deceased or can be entitled to grant letters of administration as alleged or at all. 33. With reference to the allegations contained in paragraph 13 of the said application, I say that the petitioner has made false statement or note. It is denied that the deceased in case of intestacy had no heirs, or I or my son or daughter would not be entitled to the estate of the deceased as alleged or at all. It is denied that since 1990, the petitioner had taken care or proper care of the deceased or deceased had no relatives, other relatives as alleged or at all. I say that we have, this is my lord the case. I say that we have often visited the deceased at the time when she was alive, and as such, the petitioner claiming to have taken care of the deceased or claiming that she had no other relatives are utterly false statements. This statement belies her other case. She died out of depression, loneliness. So this is contradictory, according to me. Then 34. With reference to the allegations contained in paragraph 14 of the said application, I deny that the deceased had made or published a last will or testament, or the petitioner is entitled to obtain letters of administration along with a copy of the will annexed as alleged or at all. It is denied that the petitioner is a universal legatee or is entitled to obtain letters of administration as alleged or at all. Since the will is forged and fabricated and has been brought into existence to deprive the next of the kin of the deceased, the statements had been made by the petitioner to grant of letters of administration with the publishing the citation or calling the next of the kin of the deceased to file caveat is malafide. It is denied that the application is made bona fide or for the ends of justice as alleged or at all. Then, my lord, it is stated that the application suffered from diverse suspicious circumstances, and as such, letters of administration along with copy of the will cannot be granted in favor of the petition. Now, my lord, may I take your lordship to the will? My lord, it will be my endeavor to show your lordship as to whether the will can possibly be a genuine will. I am using the word possibly be, my lord, because it in their absence. My case is it is a genuine will. And my lord, I have to show from the language of the will and the averments made in the will as to whether they synchronize with what has been said by the witnesses and whether that case has been demolished by the counsel on behalf of the caveatrix or not, or that case stands. My lord, before I take your lordship to the will, would it be a lordship's pleasure to just take the first annexure to the petition for grant of letters of administration? That is the death certificate. The petition, my lord.
Petition to the. There we go. Yes.
This is an exhibit. The original death certificate has been exhibited. My lord, inasmuch as she has said, the caveatrix, that Apurba Chattopadhyay died in 78. My lord, I'm just drawing your lordship's attention. The extent of falsity that she can go up to. My lord, this has been issued by the government of Uttar Pradesh. My lord, we understand that the death certificates at Uttar Pradesh are issued by the government hospitals. As it is, it's not the case as it is here, like the doctor comes and the doctor, if one person dies in the residence, doctor, house physician comes and checks and gives the death certificate. It is not so. If it is a natural death, then the government will issue.
So that the dead body is to be taken to
No.
hospital?
The doctor will come.
Doctor from
Yes,
hospital?
Government, yes. That is, my lord, also the deposition. I'll show the deposition of the doctor concerned who has stated this. Well, that is how we got to
How
know.
many witnesses are examined?
3. 2 attesting witnesses and the propounder. And they were all, my lord, done on commission at Benares.
On commission.
Yes, because these 2 attesting witnesses are very busy people. It was very difficult to get them, my lord. One is a doctor, one is a civil engineer involved in a project, a national highway project. So we all had to go with the leave of this honorable court, and we had to take there. So, my lord, so the death certificate, your lordship will kindly see, issued by the government of Uttar Pradesh. Date of death is 1st of February 2006. So it cannot be 78, as has been claimed by the caveatrix.
Yes.
This is a translated copy.
But this is a death certificate issued on 6/2/2006. So you are saying that the government, doctor will come and issue death certificate. That is a burning certificate or something like that.
No, my lord. From the evidence of the doctor, we get to know that the doctor comes from the government hospital, and the date of registration has been 6th of February 2006. But the date of death is 1st of February 2006.
That I get.
That is the date of death, which we are saying that is the day when she has died. But the date of registration of this certificate in the government records is on the 6th of February 2006. And this has been, my lord, your lordship will kindly see, this has been issued by the Registrar Birth and Death, Deputy Registrar Birth and Death, Corporation, Varanasi. So these are all, my lord, government authorities.
So here corporation granted.
Yeah, that is a certificate. But the death certificate, my lord, that when we go to the burning ghat, that is the physician who grants. And thereafter it has to be shown to the burning ghat, and then I suppose that is a formality here.
That's here. And in Uttar
The
Pradesh,
government doctor has to come and issue.
has to come on 1st February. He has come.
Yes.
That is not.
The date of death is only there.
Yes.
Date of death is only.
So you come back tomorrow. I have a division bench from 3:30.
My lord, may I come back on Thursday? Tomorrow I have some problem. And my lord, I was only praying that can it be marked as part heard? Your lordship has heard it on 2 occasions.
Just
Your Lordship, kindly make it parted, my lord.
termination. Just
That is what we are fearing. My lord, no, there's no. But if by chance, my lord, we want to come before my lord, make it parted, my lord, formally.
the learned counsel for the tested propounder has commenced his further argument but does not stop. As the argument has been as the hearing of the argument has been done substantially, let the matter be marked as puttered.
Thursday, my lord. May I come back on Thursday?
Just this matter on Thursday.
7th March.
7th.
Okay. Then দুটো বাকি দুটো ডেকে দাও সবাইকে আমরা দেখি ডেকে দাও
Item number 15.
My lord, in this matter, my lord, I am appearing for the caveator.
Yes.
My lord, in this matter, this
who is for propounder?
Propounder, nobody is.
Who is for propounder?
I don't see anyone for propounder.
Was present?
Was there in actually this matter after 2019 has not been taken up.
Okay.
Well, a lot of things has been happened in this matter, my lord. First citations was issued. The propounder is not a relative of the deceased. Number one, my lord. There was special citation issued. It was revoked. The order was revoked. Thereafter, this probate was turned into to be turned into a suit. But I mean, let me just.
But I do not find that the learned counsel for the propounder. Stop. It is not today করে দিচ্ছি.
Not today.
Not today. Because I have a division bench from 3:30.
Very good.
Not today করে. Yes.
Item number 16.
But if actually an order could be passed that the propounder, we could also serve the propounder.
Okay. None appears on behalf of the propounder. Stop. The learned counsel of the respondent is present. Stop. He is requested to inform the learned counsel of the propounder. Stop. Is the matter when?
Any day, my lord.
The matter 8th March.
8th March.
Next.
Item number 16.
8th March. Propounder,
16. Yes. We have waited for.
I apologize, your lordship.
You know,
only
googly. No, you all received googly. You thought that that matter will go up. We will continue.
Your lordship, the only prayer was that the propounder has already made an application for marking it as a contentious cause. And I have filed my affidavit, caveat and my affidavit in support of the caveat. It is already in your lordship's records. So your lordship kindly marks it as a contentious cause so that the TS number can be given.
একবার আসুন ওইটা লিখবেন না. The learned counsel for the propounder has submitted that let the matter be marked as contentious as caveat has been filed.
Yes, your lordship.
As caveat has been filed by brother or sister or who?
I am
by one of the legal heirs of the deceased person. By one of the only one or
yes, I am one of the caveator, your lordship. I am a caveator.
So you are appearing on behalf of whom?
Mr. Amit Kumar Bhattacharya.
You are for the propounder?
No, the caveat.
I have passed a previous order.
Because your lordship, the petitioner has only filed this application before your lordships.
No, I want to pass this order in presence of the learned counsel of the propounder. Okay, that's why I have
possibly
asked
this can be passed because it's their application, just only marking it as a contentious
come
cause.
Item number 16.
This is my application for fixation of affixing the special citations on one of the legal heirs, my lord. My lord, in this,
You are appearing on behalf of whom?
I'm appearing for the petitioner, my lord, who is the executor of the will, my lord.
Yes.
My lord,
What
in this proceedings, my lord, special citation was issued, but that has been returned back to the deputy sheriff, and it was been endorsed as not claim, my lord. So all I am praying is that, my lord, and affixing the special citation in the outer wall of the one of the deceased, my lord, one of the legal heirs of the deceased, my lord.
Report of the deputy?
That is, my lord, appearing at page 27, my lord, of the application.
That's page 27. How many legal heirs are there?
Lord, there are three legal heirs. One of them is the executor, who is the applicant over here.
Yeah.
One of them already have given the consent, my lord, and only one of and only one of the legal heirs needs to be served with a special citation, my lord, which has been served, but it has been returned back as not claimed, my lord.
Why Devasis Majumdar? No,
No, my lord.
Sorry.
That is Vikas Sen, my lord.
Vikas Sen.
Yes, my lord.
The learned counsel appearing for the propounder or executor?
Executor, my lord.
Executor, propounder now, has submitted that one of the legal heirs of the deceased has submitted affidavit of consent.
Yes, one of them, the daughter of the deceased, my lord, has already given the consent.
Name telling one of the legal heirs, namely, what is the name of the
Jhuma Sen, my lord.
Srimati Jhuma
The
Sen?
daughter of the deceased, my lord.
What লিখে দিন? As cited, or you have submitted affidavit of consent. Stop. The citation in respect of the other legal heir, namely Sri Vikas Sen, has come back with the endorsement as not claimed. Stop. The learned counsel has prayed for issuance of special citation.
Affixing this special citation on the outer
That
door.
means
It has
for,
been already
for,
issued
for affixation of special citation
in the outer wall, my lord.
in the outer wall of the
Yes, my lord.
Residential address of Sri Vikas Sen. Stop. The prayer is allowed. Department is to take necessary instruction. Is carry out the instruction work. Is carry out the. You have to take steps.
Yes, ma'am.
Returnable. Release the matter after 15 days.
It would take some time, my lord.
4 weeks. একটু দেখে নেবেন তো এই শোনো এইদিকে শোনো হয়ে গেল তো সব ডিপার্টমেন্ট ইজ টু ক্যারি আউট দি
Grateful to your lordship.
Carry out the order. Anything else is complete? Yes. I think the benches. I guess this.